Good morning, everyone. 9:30, so the inquiry is resumed. I'll just check for any housekeeping matters prior to starting in
Yes, I wondered whether you wanted, we've got a hard copy of the latest version of the conditions. Would you like that, or for later?
Yeah, I will take that.
Okay. The other thing I've got, sir, is we're going to put these in, as I said, into the core documents under inquiry documents, but I've got here hard copies of the SIL statements from the county and the NHS, which I can hand to you. They are going to go in the CDs. I understand the council have sent their SIL statement. I think it was mentioned there's a police one as well. I haven't got that unless that's what a consultation response.
There is as you know, there's a request from the police for monies under the SIL. There's a dispute between the council who say that it's in part not SIL compliant. The police's request and the council's response is wrapped up in the SIL compliance statement which you have.
Thank you. So, sorry, just so I understand, so the SIL statement has been sent, is that right?
Yes, sir. It was sent this morning to the case officer.
Oh, okay. I haven't had that yet, but I'm sure it will arrive. So,
hopefully.
Thank you for that. Okay,
if it doesn't, sir, we can of course print one out for you. But bear in mind you've got to carry all the paper with you.
Yes, I'm a bit naughty with paper, but okay. That's okay. But thank you.
If you need it, we can.
Okay, great. Okay, thank you for that. Okay. Well, if there's no more matters housekeeping, then we'll start with last witness, yes. Mr. Morrissey.
Thank you, sir. Can you confirm you are Nigel Cusson?
Yes, I am.
And you hold a BSc Hons in Geography and Economics, diploma in Town and Regional Planning. You're a chartered town planner, having been elected over 27 years ago, and you hold the position of Senior Planning Director at Pegasus Group. Is that all correct?
That is correct, yes.
And you set out in your main proof at 1.3 that you have considerable experience advising on planning matters, including appearing at planning inquiries, hearings, etc. All correct?
That's right, yeah.
You've given the necessary declaration in paragraph 1.7 of your main proof, and you've also produced a rebuttal. Does your declaration apply to your proof, rebuttal and your oral evidence?
Yes, it does.
Thank you. Now, just to understand your role in the appeal proposals, you deal with this in your main proof at 1.4 to 1.7. Up until January 26, the matter was being dealt with by your former colleague Marie Stacey. You came in January 26, is that correct?
That's right, yes.
You've reviewed the position and you've been involved in agreeing the statements of common ground, etc. since then?
Yes, that's correct.
Thank you. In terms of the scope of your evidence, you rely on some appendices. So in Appendix 1, you rely on appendix which deals with the socio-economic benefits, and that's a socio-economic statement from Richard Cook at Pegasus, is that right?
That's right, yes.
And then you rely on Appendix 2, which is an appendix that's produced by Ben Pycroft at Emery Planning, dealing with the detail of housing delivery matters, correct?
Yes.
And on matters of green wedge impact and golf need, but also in relation to the quality of Blaby Golf Centre and Enderby Golf course, you rely on the evidence of the other witnesses that have been called, is that right?
Yes, that's right, yeah.
Thank you. Good. Now, I think the next thing yes. Could we just briefly deal with, in your proof at 2.7, you mentioned the Davidson's scheme. That's been covered, I think, extensively now in evidence, both in relation to golf and green wedge. Essentially, in essence, what is the position now in relation to the grant of that planning permission?
At the time of preparing the evidence and submitting the proofs, Section 106 was in progress. That has now been engrossed, and the planning permission has been issued. So that planning permission now stands, and the decision notice is available.
Yeah, and we've heard about the effect of that previously on the golf course.
That's correct,
and
yes.
the works that would have to be done in response to that. And I think one of your appendices, we don't really need to go to it, but one of your appendices is a letter from the solicitors to the landowners explaining the circumstances in which the 106 came to be signed for the Davidsons.
That's correct, and that was one of the elements delaying the issue of the planning permission, as I understand it, but that has now all been resolved.
That's now been resolved. And I mean, the letter, I think, speaks for itself, but effectively a forfeiture notice had to be issued, and it was at that point that the golf tenant signed the 106 for the Davidson scheme.
That's right, yes.
Okay, I won't go into more detail on that for now. The other thing that you deal with in your proof, we just go to 2.23, is the withdrawal of reason for refusal 3. I mean, that's dealt with, obviously, in the Statement of Common Ground at para 6.6. It was, I think, dealt with in the council statement of case prior to that. And the council also produced a note, didn't they, in relation to that reason for refusal?
Yes, that's correct.
But I mean, where are we on that?
So the position is that, as I said, the statement of case common ground, the council have withdrawn their reason for refusal. I have addressed reason for refusal 3 in any event in my evidence, where I deal with the main issues, but the policies which were cited in respect of reason for refusal 3, effectively, I know it's not an employment site, and the policies that the council cited are not relevant, and that's been accepted by the council.
Okay, thank you. Now, in your proof, in section 3, you've got a heading meeting the need for new housing. I put a series of questions to Mr. Baker-Adams about the national policy drive for more housing, the national housing crisis, and also the level of local need and the corporate objective of this council to deliver more housing. And Mr. Baker-Adams agreed, I think, with all the points I put to him on that. Do you also agree with all of those matters?
Yes, I do.
Yeah. Okay, thank you. Now, just in relation to housing need, the agreed position is a 2.78-year supply, correct?
Yes.
And we know we've got agreed in the Statement of Common Ground, I think, or certainly in the evidence that we've produced, a number of houses that amounts to. We don't need to go back over that. Affordable housing, again, I put a number of points to Mr. Baker-Adams on affordable housing. I think all of them he agreed, and we heard from Mr. Stacey. Do you support that evidence?
Yes, absolutely. Yeah, the overall housing need is there, the 5-year supply figure. The statement in my Appendix 2 on the housing need sets all that out. Yeah. And as you say, I wholeheartedly agree with the view in relation to the requirement for the affordable housing, and that should be afforded substantial weight in the balance.
Yeah, and that 2.78-year supply, as Mr. Emery tells us, is a 1,255 house shortfall in the 5-year period.
Yes,
and that was a figure I put to Mr. Baker-Adams. Okay, and so I mean, obviously there's agreement, I think now, substantial weight to affordable housing, and I think in the light of Mr. Baker-Adams also substantial weight to housing generally.
Yes.
Yeah. Okay, could we then turn to the MPPF, which you deal with in section 4 of your proof? Obviously, we'll come in a moment to paragraph 104, A and B, but just in terms of other policies in the MPPF, paragraph 11, tilted balance, is that agreed to be applicable?
It is, yes, yeah, in light of the council's position on the housing supply.
Thank you. And then other relevant MPPF policies before we come to 104. Paragraph 61. What does That's the...
That is the element. So within the MPPF, that talks about delivery of housing, and it's paragraph 61, which, if we turn to it, addresses the requirement for affordable housing.
61, I think.
Significantly boosting supply of houses.
Yeah, so 61's boosting.
Yeah.
And then on affordable housing, I think it's paragraph 64 and 66,
yes.
Isn't it? So what support do they provide for the appeal scheme in your view?
I think they provide very strong support that 64, where there is a need for affordable housing, is identified. Planning policies should specify the type of affordable housing, a minimum proportion required. So we're meeting the national and the local policy for affordable housing.
Okay. And then if you just turn to paragraph 104, I'm going to come back to it in a moment, but just to introduce it, obviously the two criteria that are relevant in this appeal are A and B.
Yes.
On A, Gulf need, that was the evidence of Mr. Wright rather than your evidence.
That's correct, yes.
Now on B requires you to look at whether what's being lost is equivalent to what's being replaced.
Yes.
Okay. Now, in terms of what's being lost and the quality of Blaby Golf Centre, whose evidence do you rely on for that?
Mr. Smith.
Mr. Smith. And in relation to the second part, which is looking at the replacement provision and whether it's equivalent, is that your evidence?
It is. So, in terms of the additional or the equivalence and the better provision that's being provided, that is my evidence. Yes.
Right. So you're looking at are we providing equivalent or better?
Yes. Yeah.
But you're relying on, in looking at the standard of what's already there, you're relying on Mr. Smith's evidence.
I am. Yes.
Okay. Thank you. Now, can we then turn to the local plan, which you deal with at 4.25 onwards in your proof, and you begin by talking about the policies most important. And I wonder if we could also, as well as having your proof open at page 20, could we look at the statement of common ground, please? CD policy 3. And if you go to paragraph 6.4, I think it is. Yes. So it says the parties agree the following policies are relevant to the appeal, and I think there's a list then of, there's 3 tables which have got, I think, 31 policies in total.
Yep.
So they're all agreed to be relevant. And then the most important policies, so that's for the purposes of paragraph 11,
Yep.
are denoted by an asterisk. And if we look at that, we've actually got CS1, strategy for location of new development, CS5 on housing distribution, updated CS15 on open space, sport and recreation, CS16 on green wedges, and then if you go down to the next table, also DM2, development in the countryside. So those are the policies which the council and the appellant have agreed are the most important for determining the appeal. So I think it's 5 in total.
That's correct. Yes.
Now, of those, if we just run through them, policy CS1 and CS5 are not alleged by the council to be breached. You deal with these at paragraph 4.31 and then onwards in your proof. Can I just have your view, please? Obviously, because there's no 5-year housing land supply, we've also agreed, haven't we, that all these policies most important are out of date?
Yes, that's correct.
In relation to CS1 and CS5, despite being out of date because there's no 5-year supply, what weight should be given to those policies in your view?
I think they should be given some weight. I think that they're out of date. However, they do set the strategy, and I think I've stated in my evidence that the weight is for the decision maker. I think they are. There is some weight to be given to CS1 in terms of the overall strategy for housing delivery and the location of development. So, as I say, I think a degree of weight, but not significant weight, not you know, low weight, I think.
What about the policies CS15, CS16 and DM2? I mean, first of all, are those policies that encourage or constrain development?
Those constrained development.
What weight should we give to those?
I don't think that they should be given weight.
Okay. Now, in relation to CS1 and CS5, if you go to your proof at 4.35, you say, notwithstanding the lack of a 5-year supply, because some weight can be afforded, which is what you've just said to policy CS1.
Yes.
In this case, in relation to the aim to direct development to the most sustainable locations in the district, of which Blaby Town is identified as a Tier 2 highly sustainable location for development within the district settlement hierarchy. Policy CS5 further reinforces the position of Blaby Town as a key settlement within the district with a wide range of services and facilities, alongside noting its relationship with the PUA in Leicester City. The development subject to this appeal would therefore be located in a highly sustainable location within the district, as noted in the officer report, and accordingly would accord with the aims of policy CS1 and CS5. What support do they provide for the appeal scheme, in your view?
They give good support. As I've said in that that paragraph, it's a highly sustainable location.
Yeah.
CS1, the text of the policy itself says development will be focused within and adjoining Blaby, outside the PUA. So Blaby itself is a location for development.
Okay, thank you. Now, if we just return, please, in your proof at page 21, and we've got the 3 tables as well in the statement of common ground. Your analysis of compliance with all of the other policies that are agreed to be relevant, that's contained in an appendix to your proof, is that right?
Yes, that's correct.
That's appendix 3, I think.
Yes.
Table of other policies in the development plan. So that's where you run through compliance or not with all the other policies that are agreed to be relevant. And we'll look at some of those in a moment. In terms of the policies that are part of the council's reason for refusal, could we just for a moment, CS15 deals with open space, sport and recreation. And obviously we've agreed with the council that insofar as that sets those criteria to satisfy in relation to the loss of recreational facility, we've agreed with the council, haven't we, that those policies are inconsistent with the NPPF,
Yes.
out of date and carry very limited weight.
Yes.
Yeah. So effectively we look to the NPPF for those criteria rather than to the policy.
Yes.
What else does policy CS15 provide for that's relevant to this appeal scheme? What does it require?
So CS15 has it deals with the provision of open space in addition to the protection of open space, which is the latter part of the policy.
Right. So protection of open space is what the bit on protection of open space is what we've agreed with the council is inconsistent.
Yes.
But it also looks at promotion of open space.
That's correct, yeah. So there's a table within CS15 which sets out the space, and what it says in paragraph 2.3 of the...
So do you want, it's CD 6.19, if you want to look at it, CD 6.19. So CS15, yes, so you were saying paragraph
2.3.
Yeah.
The policy sets standards for open space. To say there's no specific standards for the provision of outdoor sports space, but there's a table within the policy itself which sets
that's the one.
The standards of space.
Electronic page 3.
Yes.
Is that right? Yeah. So it's got parks and recreation ground,
That's
natural
correct,
green
yeah.
space, informal open space, play, allotments, etc., etc. And we'll come to this later on. But does the scheme comply or not with that policy in terms of the provision of open space, sport and recreation?
Yes, it does.
Yeah. Does it meet, or does it just meet, or does
it exceeds?
It exceeds. Okay, now then CS16, could we look at CS16 please? That's CD 6.11. And I think maybe if you could just take us through what your key observations are on this policy.
So yeah, CS16, that's at page 80 of the local plan. I haven't got the CD reference, I'm afraid, for the local plan itself, but the first thing I'd say is that, as it's agreed, the green wedge designation is not a landscape designation. The site itself, it's a policy constraint on the site, but the site isn't a valued landscape, as we heard the other day. And there's no formal landscape designation and no landscape issue within the reason for refusal arising from CS16, or any reason. The other element of CS16, which is critically important, I think, is that whilst it sets the purposes of the green wedge, it does allow for development. I don't see it as a prohibition of development in the green wedge, and indeed there's a clear balancing exercise that the policy states should be undertaken in regard to meeting. So the need for states within the policy, the need for green wedges will be balanced against the need to provide new development, including housing, in the most sustainable locations.
And I mean, on our case, on the agreed case, is there a need for housing?
There is.
Yeah. And are we in a sustainable location?
We are, yes.
Now, I mean, obviously, you've referred to, we've been to this a number of times, but if you go to electronic page 3, you've got green wedges are important strategic areas. They'll be designated too, and then there's those 4 purposes, effectively, that are set out there, and they've been explored extensively in the evidence. And you'll see the last 2 are the green lung and the recreation resource. And then similarly, if you look at the very end of the boldened policy text, we've got the land use or development in green wedges should.
Yes.
And then there are 3 things that they should do.
Yes.
Any observation on the word should?
Yeah, I think it's a very important word. It doesn't mandate, it's not a must. Right. So I would take that as something that the policy is seeking to achieve.
Yeah. And I mean, obviously, we've agreed in the Statement of Common Ground there will be some impact on green wedge purposes. But in your view, if you look at B and C, retain and create green networks between the countryside and open spaces within the urban areas, do we comply with that in your view?
Yes, we do.
Yeah. And what about C, retain and enhance public access to the green wedge, especially for recreation? Do we comply with that?
Yes, we do. Yeah.
Okay, thank you. Now, can I just ask you also, we might as well deal with this here, 7.16.3 of the explanatory text.
Yes.
What does that say?
So 7.16.3 says to consider a green wedge to be functioning effectively, it needs to be fulfilling one or more of the functions of the policy.
Right. So you said a moment ago that our scheme complied with B and C.
Yes.
So if this land remained in the green wedge, which it would after planning permissions being granted, what does 7.16.3 tell us? So
it would still be functioning effectively by meeting actually 2 of those purposes. 2 of those, yeah.
Okay, thank you. Now, can I just briefly deal with this? You mentioned in your proof, I think it's, just give me one moment. Yes, you mention, I think, policy CS17. This is paragraph 4.53 of your proof. So you say, I consider the policy through incorporating the acknowledged balance with the need to provide new development does not provide a prohibition on development. Indeed, I note in the context of policy CS17, which identifies areas of separation, the green wedge designation is not even the top of the council's hierarchy of land identified by the local plan as performing the function of preventing coalescence. I note also that even for these higher performing areas of separation, policy CS17 incorporates the allowance of the need to retain land free from development to be balanced against the need to provide for new housing. Now, that's the way you put it. You put it in terms of a hierarchy.
Yes.
With CS17 at the top and CS16 below it. can I just have you, I think the way I put it to Mr. Baker-Adams might have been slightly clumsy, because I asked him whether CS17 was stricter, which may not be the right way to put it. How would you characterise it?
So I think that because they're two separate designations within the local plan, there are differences. But the reason I'd said that it was a hierarchy and it was more, it's degree of importance. So if you look at the policy CS17 for areas of separation, effectively they're smaller areas and they're not contiguous areas of the green wedge. But for that reason, I think that the council give them more importance. And if you look at paragraph 7.17.1, 7.17.1,
Is that in policy CS?
which is under the policy CS 17.
So that's CD 6.12.
Yeah.
Yeah. So paragraph, sorry, you say that again,
7.17.1.
Yeah.
Again, it's similar to the green wedges. It's important to note that this areas of separation are landscape designations. However, they perform very important function in ensuring coalescence between the settlements is prevented. And I think that it's that stronger wording. I see that wording as stronger than the wording that is within the supporting text of CS16, where and that's really where I've come from in terms of what I've said in 453. Yeah. But I think the critical point being, whilst I'm saying that they're more important, and a stronger policy designation against development in those areas, that policy CS17 still incorporates the balance that the council makes in CS16. The need to retain will be balanced against the need for new development, and it really runs to the importance of that balancing exercise and the policy that the council have to meet this strong housing requirement that we've identified.
Yeah. Thank you. Okay, so could we then turn to the first main issue? We've talked about the policy, but the first main issue of this appeal is obviously about the impact on the green wedge, and you consider that from paragraphs 5.5 onwards of your proof. So there's a couple of things I just want to ask you about. Obviously, a lot of this has been covered by the earlier witnesses. But
yes.
Can I just ask you, but when I cross-examined Mr. Collins, in particular about the gap between Countersthorpe and Blaby, and why he had not regarded any impact on the gap that we would have there as being material or significant, he said that there was effectively a sort of a trigger point that one reached in the policy, i.e. you could have some level of impact on coalescence without tipping over to cause harm within the policy. Or,
yes.
or you caused harm, but it wasn't enough to, I think, I can't remember where he put it, let me just see where he put it, that offends the policy, I think was the way he put
yes.
it. So what does that tell us about how you apply this policy?
It goes back to the point I was making about not being a prohibition on development, and the point about the policy saying should. There is a degree of flexibility. It's a positive policy for protection of the land. However, there is an acceptance, an inherent acceptance that if development does take place, there will be impacts.
Yeah. So if Mr. Collins is right about this, if you have some impact on coalescence, what does that mean? Does that mean the policy is automatically not compliant?
No, it's not breached. A degree of impact, it has to be acceptable, but it can be accepted.
Right. But then even if you find, well, actually the impact on coalescence is enough to trigger the policy harm,
yes.
What do you then have to do under the policy?
Then you need to consider that balance. How does the need for retention of the green wedge balance against the need for the development?
Now, if you've still got policy CS16 open, which is CD 6.11, again on electronic page 4 we have those three ABC, retained the open and undeveloped character of the green wedge, etc. Going through that list. Now, I asked Mr. Holliday about this, but he spoke about the Glen Parva decision, which I don't want to go into detail at this stage, but in that case, because of the public open space provision that was being made there, the council held that B and C were met.
Yes.
Yeah. If that's the position with Glen Parva, what do you say the position is here?
I think the position will be the same. Those criteria are met.
And I mean, are we offering more or less public open space in absolute terms and percentage terms?
In both absolute and percentage terms, there's 10.1 hectares of open space being provided here. I think Glen Parva, from memory, was around about 1 hectare.
And I think the percentages I've put, I won't go back over those. Can we then also look, please, in terms of this issue about the balance under CS16, your Appendix 10 of your proof, it's a document we've been to, I think, quite a few times, but it's your Appendix 10. Which is the green wedge permissions.
Yes.
So you've got a map, figure 20, showing other grants of consent in the green wedge, and then setting out the planning history.
Yes.
Yeah. What do we take from this table? What does it show us about policy CS16 in your view?
It shows that the council are whilst protecting the green wedges, are allowing elements of development within the green wedge as well, which accords with meeting that need.
Okay. So, in terms of where we get to on compliance with policy CS16, so I think if we look again at those 3 criteria, you've already told me you think we comply with B and C. Yeah.
Yes.
And to the extent that we are having an impact on the green wedge under A, which is retain the open and undeveloped character, or on coalescence, to the extent we're having some impact on those, and to the extent that they meet the policy trigger that Mr. Collins was referring to, what do you say about the balance within the policy? How does it come out in this case?
I think the balance in terms of, yes, acknowledge there is a degree of impact. I think that impact is acceptable, and yesterday we heard about the impact on the green wedge being limited and localised. And in terms of the balance, we've seen a very substantial housing requirement, a substantial requirement for affordable housing, and to my mind that balance falls in favour of development.
Okay, thank you. Now, there's one other policy I just want to look at. You deal with this, I think, at 5.31 to 5.36, and that's policy DM2, because that was cited in the reasons for refusal, albeit the council don't now pursue a case that it's breached. But if you go to CD 6.20, you should have DM2.
It's the wording of DM2.
Yeah, DM2.
Yeah.
Yeah. So there's an area designated as countryside on the policies map. Development proposals consistent with course of GCS 18 will be supported by the following criteria are met. Now, obviously the council's position is this isn't the most relevant policy, but if it were applicable, do we comply, in your view, with the criteria in A, B and C?
Yes, we do. I mean, I know the first bit of the policy is a supportive one. It's a positively couched policy, so it would support development that meets those criteria. There's no objection in regard to the landscape effects, which is the first criteria. A landscape visual assessment was undertaken, and the councillor agreed with that. The second criterion is satisfactory relationship with nearby uses, and again, I touch on elements of the the other material considerations, the noise and traffic and all of that in other parts of my proof, and with reference to the consultation responses. So again, my view is all of that is satisfactory, relationship with neighbouring uses is met, and there's no issue around vitality and viability for town centres, which is the third criterion. So yes, in summary, yes, I think it's met.
Okay. Now, before we leave main issue 1, which is Green Wedge, in your rebuttal, please, page 4, you set out the email correspondence in its appendix 1, where consideration is being given by the council as it moves towards its Reg 19 consultation to allocating an area of land south of the appeal site. And if we go to your appendix 2, there's a map which shows the different colours of land ownership and the area that's being contemplated for allocation.
Yes.
Now, I just want to understand this with you because I think Mr. Baker-Adams agreed that obviously it's an early stage, we haven't even got the Reg 19 yet, so he said limited weight. I mean, I think you say in your proof about the Reg 19 process, no weight.
Right.
Okay, so if it's no weight, why are we referring to this? Why is it relevant?
I think it doesn't have policy weight in that it's not an allocation within the plan, but it is the correspondence is clear in terms of it's something that the council are considering, and the relevance of it is in relation. We looked when hearing evidence earlier about the Green Wedge at the plans and in the Green Wedge assessment and zones A, B and C, or areas A, B and C. This is very much a large portion of area B, which is an important area identified in that assessment between Cantersthorpe and Wheatstone. And I think the reason for putting it forward in the evidence is to say, well, the council are looking for development to meet the housing requirement, and they're having to look at the Green Wedge, and they're prepared to look at what is quite a significant part of the Green Wedge.
What's your view? Can the council meet its needs outside of Green Wedge?
No.
Okay, thank you. Right, can we turn to main issue 2, which is the loss of the golf provision? I think you deal with that in your main proof, 5.43 onwards.
Yes.
Now, you've already referred to the effect of the Davidson scheme, and we've been through that, so I'm not going to go back over that. You need to help me, obviously, with paragraph 104B and the equivalent or better in terms of the replacement. So how does, just help us, how does the test work? Does it have to be like for like?
No, it doesn't.
So golf, does it have to be golf for golf?
No.
Does the amount of land in recreational, sports, etc. use have to be the same before and after?
No.
Okay, so we've obviously heard lots of evidence about the quality of Blaby Golf Centre were it to be lost, and I know you rely on Mr. Smith for that. Can I then understand, in terms of what we're offering in replacement, can you run through the offer that is there in terms of the replacement? Run through it and then explain why you take the view that you do, that we comply with 104B.
Yes, so the proposals incorporate open space and significant landscape and enhancements and space within the development itself, and also then Section 106 contributions. So just, and I set it out, and it's in the statement of common ground, I think, CD 5.3.
Okay, let's go to CD 5.3.
If we look at paragraph 855. So in terms of the 855 outlines the agreed open space on-site public open space provision meeting the open space standards, and there's a table there. So we have a policy accordance in terms of what we were talking about for the council standards. But over and above that, so that table indicates the open space assessment requirement of 1.648.
So that's what we would be required
Yes.
to meet as a minimum to meet the policy,
As
is
a
that
minimum,
right?
yeah.
Okay.
We're actually providing, as we said, 10.1.
I think it's 10.5, I think is
10.5.
agreed in the statement of
Yeah.
common ground. Let's have a look. Let's just have a look at that. Yeah, so if you go to paragraph 5.3 of the statement of common ground, electronic page 11, third bullet, approximately 10.5 hectares of which, that's the development, the majority would form publicly accessible formal and informal open spaces, including an 11:11 youth pitch, community orchard, natural green spaces and walkable routes. Yes.
Yeah.
So, in excess of the policy.
Yes.
Okay.
The over-provision will help meet existing deficiencies. So in the open space study the council did, they were identifying the wider area of deficiencies.
Right.
It will provide public access to the area of identified. So again, we saw a plan earlier in terms of what will be developed and also what will be left as open space within the site.
Yeah.
All of that would be public accessible land. Currently, only the public rights of way are accessible across the golf course.
So the footpath is the only public
That's
accessible
correct,
land.
yeah. We're providing social value. Mr. Cook's statement, which was my appendix 1,
Yeah.
makes reference to the social value. The football pitch, which is also noted in paragraph 5.3 of
Yeah.
the statement of common ground.
Yeah.
That arises from engagement with the council's health and leisure consultation and referenced in CD 312.
Yes.
And similarly, the Section 106 obligations, so £61,000 towards a 3G pitch at Holmes Park, 181,514 towards facilities at Oakfield Park, £17,535 to the wickets at Northfield Park, so the cricket provision. Those are all direct response to that consultation response. And in addition, then there's the £100,000 golfing facilities.
Yeah, I'll come to the golf one in a moment. Just asking you about these other provisions, so the on-site and also the contributions off-site. Just to ask you about how that compares to the current situation. You've explained that there will be more public open space post-development than pre-development. How much is the existing footpath used? What does your survey tell you about that?
So there, as we've seen, there's two footpaths. One runs along the northern perimeter of the site, effectively, and exits onto. Sorry, I've forgotten the name of the road. The western side, the eastern side.
Winchester Road.
Sorry.
Winchester?
Winchester, yes, that's correct. So on the northern aspects of the site, and then there's the second path that cuts diagonally and comes out further south on Winchester. And the survey indicated that the much more heavily used route was the northern one. And so I think what we were taking from that was that the route across the golf course is one that's not a preferred route.
Yeah. I mean, I suspect it will be put to you that if you compare the present situation with the post-development situation, currently the majority of the site is a golf course. I mean, obviously there's a lot of built form as well, but at that frontage, but most of it's a golf course, whereas I think the position is only about 65% of the site will be public open space, green infrastructure, post-development. So overall, the amount of open space is less. I'm sure that will be put to you. But the position is, what about in terms of public accessible? What's the position?
That is a considerable increase in the public accessible open space. It's commercially accessible at the moment. You have to pay to get into the golf course.
Yeah.
Other than to use the footpath.
Yeah. So commercially accessible becomes publicly accessible.
Yes.
Okay, thank you. Now, I was going to ask you about the, and in terms of the football provision, you've mentioned that was provided because that was requested by officers, CD 3.12. Why did they want that football pitch? Well, why were they urging that to be provided?
Because within the council's own study, it was identified that there was a shortage of football provision.
Okay. Now, I think all of those contributions that you went through, the Holmes Park one, the Oakfield Park one, the Northfield Park one, they're all agreed with the council as being SIL compliant, so reasonably related, and etc. The one that's in dispute is the golfing facilities one, and obviously the suggestion is that that's not SIL compliant. So just to understand that, why do you say that the golfing contribution is SIL compliant?
So I refer to this as paragraph 572 of my proof, and I refer to the statutes, the SIL regulations, and the tests within that being necessary to make development acceptable in planning terms, directly related to development, and fairly and reasonably related. So I think it is, you know, as the council have made a case that there is, as a consequence of this development, there will be a loss of golf.
Right.
And so that's really why, in my view, the mitigation of additional provision to golfing facilities is a directly related and reasonable.
So it's responding to the council's contention that there's a loss of golfing facilities. Now, I mean, obviously, it's also agreed, and we heard about this yesterday, it's agreed by both the golf expert witnesses that if Blaby Golf Centre were to close, a number of people who currently use it would go to Enderby.
Yes.
To what extent is that relevant to whether the SIL tests are met?
Well, I think it is highly relevant because the consequence we heard yesterday of the closure of one of these golf courses is to make the other one busier, and so there will be a need to accommodate that additional busyness.
And are there things that need to be done at Enderby?
Yes, there is, for the existing situation in regard to drainage. There's also potential desires to invest in terms of the virtual golf. There's things that can be done to that side. Yeah,
the virtual golf, and I think they also mentioned they had aspirations on crazy golf, I think we
Yes.
discussed. But, I mean, obviously, I think the point that Mr. Baker-Adams was making was that the money is being provided to the council to pay for golfing enhancements or whatever it may be. But it doesn't say where the money has to be spent. Does that matter in your view?
No, because it is earmarked specifically for golfing. And it's within the council's gift to decide where to spend that, so long as it is on golf facilities. But given that the council are the owners of Enderby, and it's also been identified that an effect of this development would be a change in what happens at Enderby, then it would seem reasonable to me that the council would spend or could spend it there. It's in their, as I say, it's in their gift to do so.
So in conclusion then, obviously the key policies here, CS15 we agree is out of date, very limited weight in terms of protection of open space. But insofar as that policy requires the provision of open space, are we compliant with CS15?
We are.
In relation to MPPF 104, if we just return to that again, in terms of compliance with A, that's for the golf witnesses. In terms of B, the loss resulting from the proposed development will be replaced by equivalent or better provision in terms of quantity and quality in a suitable location. What's your view? Is that test met?
Yes, my view is that is met.
Good. Now, could we please look at your assessment of the benefits, which I think in your proof, if we start at paragraph 9.27, I think it is. No, if we start at 9. actually in your proof. So this is where you run through the benefits of the development.
Yes.
So I'm going to ask you about your view, and I think we'll also look at where you just briefly where you agree or disagree with Mr. Baker Adams in terms of where we got to on his evidence. So you start by looking at the economic objectives, and in relation to, you break this down into two parts, don't you?
Yes.
So the first part is 9.16, employment benefits include arising from the construction aspects of the scheme and the operational benefits from increased household spend, council tax and the social value, which we talked about earlier. You say significant, positive.
Yes.
And then in relation to the replacement retail, sewer generous uses, etc., moderate.
Yes.
Right? Now, I think what I got to with Mr. Baker Adams was moderate on economic effects overall. So that's the position between
right.
you. You've got moderate
yes.
and significant, depending on which ones.
Yes.
He's got moderate. Okay. Market housing and affordable housing, you both agree now substantial positive weight.
Yes.
So I don't think we need to spend time on that one. At 9.21, what are you giving weight to there?
So that's the delivery of the large number of homes in the sustainable location.
Yeah.
So it's really about the development strategy, meeting the development strategy, which was CS1 and CS6.
5, CS5, CS1 and CS5, yeah. Okay. And then, so that's, I don't think that's not something that Mr. Baker Adams has put in his proof expressly, although we agree it's a sustainable location.
Yes.
9.22, the landscaping proposals, and then you've got the open space matters. I think he says 6.15 hectares there. I think we've agreed with everything. It's 10.5 hectares. You give that significant
yes.
weight. I think we got to with Mr. Baker Adams in the end. I think he agreed moderate
right.
by the end on that. You then, what are you giving weight to in 9.23?
That's so I'm saying there, the appeal proposal makes effective use of land in accordance with the appropriate density and the mix of development that's achieved, and that is sort of in accordance with the NPPF.
Yeah. Okay. And then you then give moderate weight to BNG, which is I think where we got to.
Yes. Yeah.
With Mr. Baker Adams. Now, on the disbenefits of the development, 9.25 and 9.26. So on Greenwedge, you say limited.
Yes.
Negative weight. And Mr. Baker Adams' proof says moderate. So for all the discussion of Greenwedge that we've had in this inquiry, the difference between you is what, limited or moderate?
Yes. Yeah, I think that's my understanding.
And then paragraph 104, this is probably where the biggest difference lies between you, I think, because you say limited weight to the loss of the golf provision, and Mr. Baker Adams has significant
yes.
weight. Okay. Now, just help me with this for a moment. Obviously, we know, don't we, that if we look at Mr. Baker Adams' assessment of the benefits and the harms, he's got them in his proof in that table near his 4.5, but we have to make some modifications given his oral evidence, because he changed some of these weights and he also added a couple of benefits that are not in this list. So I want to just have a look at that table in his proof, but also update it essentially,
right.
and see where we stand. Because what I want you to ask you ultimately is, if the inspector were to accept not your weightings but Mr. Baker Adams' weightings, where would we be on both a flat balance and the tilted balance?
Okay.
Yeah. Okay. So I want to ask you that in a moment. But before we get to that, so can we just look at this? So the first one is the housing,
yes.
both private and affordable. And although I think we've moved to substantial weight rather than significant
yes.
weight in that table. So that's the first one. So we've got one benefit with substantial weight. We've then got the Section 106 contributions for infrastructure, and Mr. Baker Adams agreed that if the inspector found that the golf contribution was still compliant, he would move that to moderate rather than limited weight. So we've got one more benefit that's moderate if the golf is included. B&G 10%, it says limited here, but he went to moderate, so that's another benefit, isn't it, with moderate in it. And then before we get to the harms, we added two that he hadn't included. I put to him economic benefits, he said moderate. The new public open space, the football pitch, etc. on site, again, he said moderate. So I think that where that gets us to is that Mr. Baker has 5 benefits, one of which substantial weight, 4 moderate weight.
Yes.
Yeah. And against that, he's got 2 harms: significant weight for the loss and recreational, and moderate for the green wedge. Okay.
Yes.
So if the inspector accepted those as the weightings, they're not your weightings, although you're not a million miles apart, but they're not your weightings.
Yeah.
Assuming this wasn't a tilted balance case, a flat balance case, where would we be on those?
I think that just on a flat balance, it looks to me as though that the benefits outweigh the harms.
Yes. And if we're in a tilted balance world, what's the position?
The position is that the harms do not significantly and demonstrably outweigh the benefits.
Okay, thank you. Right, can you just give us then, please, your overall conclusion?
So as I set out in from paragraph 9.33 of my proof, that overall the conclusion is that I've concluded that the proposal accords with the development plan read as it should be as a whole, and as such is in accordance with the NPPF, and that the planning permission should be granted without delay. However, in the circumstances of this appeal, paragraph 11D of the NPPF is engaged. I believe the appeal proposal represents sustainable development in accordance with the NPPF as a whole, and having particular regard to the key policies for directing development to sustainable locations, making effective use of land and securing well-designed places, to providing affordable homes where adverse impacts identified fall substantially short of significantly and demonstrably outweighing the benefits of the scheme when assessed against the policies of the NPPF and the development plan. The most important policies of the development plan are out of date and are afforded limited weight, and the appeal should be allowed, planning permission should be granted.
Thank you. Thank you very much. Those are all my questions.
Thank you.
I wouldn't mind if we could just have a 5-minute comfort break. That'd be all right, or 10 minutes, however you want to do it.
Well, I was just wondering if it's worth the opportunity to get a cup of coffee.
Even better, yes. Have to take a longer break, so
10 minutes? Yeah.
Yes, sir.
Okay, so the inquiry's adjourned till 10:40. Thank you. Okay, so 10:40, inquiry is resumed. Mr. Robson.
Good morning.
Morning.
Some points of agreement first. The tilted balance in this case is engaged because of the absence of a 5-year supply.
Yes.
And the effect of that is not to override section 38(6). You still need to determine the scheme in accordance with the development plan and other material considerations.
Yes.
And of course it remains, even in the tilted balance, a plan-led system.
It does.
Now, out-of-date policies in the local plan, really we're looking at two, CS15 and CS16 as the ones we've been debating this last fortnight. CS15, it's agreed, in part is out of date through conflict with the wording of the NPPF 104, and CS16 is out of date by virtue of the lack of a 5-year supply.
Yes, I think CS15 is also affected by that 5-year supply point in that it is a policy which constrains development.
And of course, if this wasn't a tilted balance case and there was a 5-year supply, CS16 would not be out of date, it would remain in date.
Yeah.
Right, now in terms of the weight that can be given to out-of-date policies, we know, don't we, from extensive case law that that's a matter of judgment for the inspector. And the inspector is not bound by your view, he's not bound by Mr. Baker-Adams' view, and he can come to his own independent conclusion on weight.
I think I said earlier it was a matter for the decision maker.
Yeah, provided of course his reasons are clear and intelligible. Your position earlier was that CS15 and CS16 should be given no weight. The effect of this, is it not, is to disregard the development plan?
No, it's not, because the development plan should be read as a whole. There are policies within the development plan that are still relevant and are not out of date, and I've referred to a considerable number of the wider policies in respect of the development plan in my proof.
Okay, so is this a point that your case isn't that CS15 and 16 should get no weight, it's the policies pulling in different directions and overall compliance with the development plan? Is it that point you're making?
I think so. I think I put it in my conclusion that in the position I see it, as I see it, the development accords with the development plan read as a whole.
Yeah.
If there is conflict with CS15 and CS16, then the weight to be given to those two policy conflicts are mitigated by the fact that they're out of date.
Understood. In terms of how the inspector should approach the weight to benefits, the same as applies as the way he should approach out-of-date policies. Matter of judgment for him, not bound by you or Mr. Baker-Adams.
No.
And when it comes to weighing up those benefits, we know a number of things, don't we, from the amount of times it's been litigated, that the inspector should not adopt an overly legalistic approach. We know that, don't we? I don't know. Okay.
I can't take a legal view on things.
That's fine. Well, let me put the other part to you then. We know, don't we, that decision makers shouldn't take a mechanical or quasi-mathematical approach to
No,
the
it's
balance.
not. It's not a mathematical judgment.
And it's not a case of counting up the number of adjectives on one side of the balance and the number on the other side and that determining the outcome of your balance.
No, but it is a factor, you know, the way in which decisions are made in terms of a balance is the balance of effects. It's weighing those balances. What is the basket of effects? It's been talked about in other circumstances, you know, and in one basket you have the benefits, and in the other basket you have the harms.
Yes, heavily overlaid, of course, with a matter of judgment and avoiding a mechanical, quasi-mathematical approach.
Yes.
Good, thank you. I want then to move on to the first reason and green wedges. This point that you've made around CS16 and CS17 as a preliminary point, and there being a hierarchy. Firstly, there's nothing within the development plan that says there is a hierarchy between CS16 and CS17, is there?
No, that was my terminology, and I explained it's about the weight and importance that I see the plan giving to those two distinct designations.
Yes, distinct designations that apply to distinct areas.
Yes.
And we know, don't we, that we shouldn't imply into policies tests that aren't there.
Yep.
Thank you. Right, then let's look at CS16, CD 6.11. Do you have it in Mr. Cusson's brief, sir? Yeah, thank you. So the bold heading CS16 green wedges, and then it gives us in italicised text the strategic objectives the policy aims to meet, and the policy itself is in bold, isn't it?
It is.
So the strategic objectives listed above are not part of the policy text.
No, they're strategic objectives of the development plan.
Yes, and so they're not tests that the policy seeks to apply to development.
No. They're included as the strategic objectives that the local authority or the planning authority views this policy in assisting achieving.
Yeah, exactly. It's contextual, isn't it? It's saying these are our broad strategic objectives.
Yeah.
The policy is the specific DM tests that are applied to achieve those objectives. And so it's no part then of your case to say that the inspector needs to apply the objectives given as any form of development management constraint. They're there for context.
They are there for context, I think, but they are stated alongside the policy to say how it's really setting out the purpose for which the council have this policy to help it achieve those objectives.
Yeah. And we need to take a similar approach, don't we, to justifying text, which is there as an aid to interpretation of the actual tests within the policy.
It's not the policy itself.
Absolutely. And so, and I think this was agreed with Mr. Holliday, and we'll see if you agree as well. When we look at 7.16.2 of the justifying text, which gives the primary functions as preventing coalescence of distinct settlements and providing potential as an important recreation resource, that is the aid to understanding what the focus of the tests are in the policy, those being the 4 bullet points at the top,
yeah,
and the 3 tests at the bottom.
Yes.
Now, the key issues then between us with regard to policy CS16 is whether the development will have the effect of merging or coalescing between Blaby and Whetstone. That's the Lutterworth Road side.
Yeah.
And then I think there's a sensible point of agreement being reached with Mr. Collins and Mr. Holliday that it's less sensitive over on the Winchester Road side, but there is still relevance to the CS16 policy because of the experience of the pedestrian that walks around the northern pedestrian route and down through the golf course. So it's not irrelevant, but it is less significant.
It's not irrelevant, but I think, as Mr. Collins accepted, any effects on that eastern side of the site are ones that are acceptable within the context of the policy.
And just staying within the terms of the policy, there is the internal balance. The need to attrain green wedges will be balanced against the need to provide new development. And again, just to get agreement on a straightforward point, this is done on a flat balance, isn't it? I.e. the conflict with the green wedge policy versus the provision of housing.
It is.
The tilted balance doesn't impose itself into development plan policies in that way.
No, on a flat balance, one needs to be cognizant of the weight that you would be accorded to the requirement for that need, that housing development, and the fact that the council are not able to demonstrate their 5-year supply is a very significant aspect of the weight to be given to that need. So whilst, yes, it's not a tilted balance, the reason there is a tilted balance is because there is a considerable need, and that need needs to be taken into account even on the flat balance.
Yes, which is why we've agreed a weight to market and affordable housing.
Yeah.
The outdoor recreation exceptions, i.e. appropriate uses within the green wedge, which now, just over the page on the policy, uses that are appropriately located in green wedges include agriculture and outdoor recreation. We agree, don't we, that the golf course on the east side of Lutterworth Road meets this exception as an outdoor recreation use?
The golfing and leisure element of what's on the site currently would fall within that outdoor recreation. I think there's not agreement in terms of the other elements of the more commercial aspects of the site, which have become established on the site and are not uses listed there.
No, and I think it was agreed with Mr. Holliday that where one has an outdoor recreation use like a 9-hole golf course, a pitch and putt and a crazy golf course, which is an accepted use, an appropriate use, one would expect a car park to allow those playing there to park their car to play. So that would be appropriate, in principle.
In principle, yes.
And the supporting buildings, such as changing rooms, a cafe for players to get something to drink before and after, or a bite to eat, would also be anticipated at that type of use.
Yes.
And the issue between us, which the inspector will have to determine, is whether the car park's too big, whether the recreation buildings are too big, and then your add-on of the commercial.
Yes, by, you know, a dance studio, a taxi office, and other elements such as that are on site don't fall into those uses. That would be not normally complementary to a golf course.
Should have asked Mr. Smith yesterday if dancing would help improve your swing.
He may have helped you on that.
I missed a pun there. Then the inspector needs to apply those 3 tests, A, B and C. Yes?
Yes.
The first part, retaining the open and undeveloped character of the green wedge. Mr. Holliday, I think unprompted, said that one approaches this in a similar way to one is looking at openness within the green belt, i.e. a visual and a spatial element, and you agree with that? And Mr. Holliday accepted that there would be a loss of openness that would be caused by the built form of the development, and you agree with that?
Yes.
And so you agree then that when the inspector comes to look at point A, there is at least a partial conflict with that through failing to maintain the open and undeveloped character, the spatial element of the open and undeveloped character of the green wedge.
There is, and I think, you know, but we've acknowledged that there is a degree to which development is occurring within the green wedge, and that's why we're saying that the balance that the policy suggests you should require should be taken. And but it's also bear in mind what we've said about the proportions of the site that are being developed. So I think there's 65% of the site which is entirely left open. The remaining 35% that will be developed will have housing, but it will also have areas of landscaping and small areas of open space within it.
Do you have Mr. Holliday's appendices?
Yeah.
And I'd like to go to figure 19, please, which is on electronic page 22.
Yep.
Do you have that? This is the aerial view.
Yes.
And it's your client that's proposing this to the inspector, and so I'm assuming that you consider it to be an accurate representation of the illustrative master plan.
I do, yeah.
So when the inspector comes to look at the spatial element of CS16A and whether the development would result in, would retain the open and undeveloped character of the green wedge in this location, he can rely on this as part of that assessment, can't he?
It's been provided as part of our evidence.
And he can note, can't he, that the land between the business park and the settlement edge, which I think includes the Davidson scheme as annotated, is almost entirely infilled with built form.
Well, this image shows it's an indicative image of an indicative scheme.
But just pause you there if I can, but it's the only indicative scheme that's proposed by your client and you,
yeah, absolutely.
the inspector, and this is an accurate representation of it.
Yeah, it also, as you mentioned, it shows the consented Davidson scheme. So what can be seen on there isn't all just this proposal. The Davidsons has got planning permission and will be coming forward anyway. But that this image should be read alongside the illustrative master plan CD 219 to understand the scheme, which shows the extensive bund of planting along that southern boundary of the site. It also shows the proposed area of open space and attenuation ponds to the southwestern corner of the site adjacent to the business park. So I think what I'm saying is, yes, this image shows the development, however, it should be read in the context of all the other supporting information, and it's also, unless you take a view from a helicopter or some other aerial view, it's not a view that most people are going to have very often. What will be perceived of the development will be by the general public will be what they'll see from the highways passing the east and west of the site, and also from the development within it and the open space we're creating within it. So yes, it's an aerial view of the scheme, but I don't think it's determinative.
It's important to be, because there's different elements of this part of CS16, precise in what we need to consider and precise in what we can use to form a view. And my question related to the spatial element,
yep,
which more naturally lends itself to considering on plan, is built form going where it isn't currently going? And this, I think you've agreed, assists in looking at that spatial element.
Alongside the other information
Alongside
that's
the other
submitted to the
information.
application.
With regard to the visual part of CS16 and the merging of settlements and test A, we can agree that there's a number of different, there's the viewpoints provided by Mr. Holliday which need to be considered, there's the viewpoints provided by Mr. Collins which the inspector will need to consider.
Yes.
And you'll agree that, and obviously there's this figure 19 which the inspector will need to consider when looking at that visual element of open and undeveloped.
Yeah.
And the approach that Mr. Holliday, and Mr. Collins took repeatedly in their evidence, both in chief and both in cross-examination, was it's the experience as one moves down Lutterworth Road, and you'd agree with that way of looking at the visual element of open and undeveloped.
Yes.
Right. So when the inspector comes to think about how that experience will change, the only evidence that he has in terms of the potential effect of the development, not the only, a key part is this figure 19. Because it gives him an indication of where the housing is going to sit, the 2 to 2.5 stories as agreed with Mr. Holliday, and the commercial development along Lutterworth Road.
It's one of the pieces of evidence that's been put forward. as I say, it sits alongside. There's a design and access statement. There's the images you've referred to of the existing viewpoints on Lutterworth Road. So yes.
Lots of the DAS and Mr. Holliday's evidence give lots of, and Mr. Collinge's, lots of descriptors, but in terms of attempting to visualise it and form that view, this forms a key part of that assessment, doesn't it? Because it is the only visual of the scheme as proposed to appreciate it along Lutterworth Road.
It's the only visual that's been presented in Mr. Holliday's evidence, yes.
I'm not going to ask you any more in terms of effect, because I think we've got that from Mr. Holliday, and I know that your answer to my question is going to be, I rely on Mr. Holliday, and so I don't think it necessarily assists us. But I want to look at how you've approached in your evidence this CS16A test. So if we could go to your proof, please. And it's 5 point... starts on PDF 35, paper 31. You've got policy considerations.
Yes.
And you introduce at 5.17 the Glen Parva application.
Yep.
Stating that although the land use was, conflict with the Green Wedge land use was noted, the tilted balance was engaged, and the point you seem to be making here is that there's an inconsistency between the way the council has balanced housing need against impact on Green Wedge policy.
Yes.
Right. Could we go to the officer report, CD 13.5?
Sorry, CD 13.
13.5.
Got that now.
Thank you. Now, the point that you seek to make is this consistency point. You argue the council's been inconsistent in how it's looked at this policy in various different locations. Right, so let's just agree some principles first. You accept, of course, don't you, that each individual development is treated on its own merits?
Yes.
The inspector or any decision maker must consider the specific individual elements of the development proposed.
Yeah.
And that the inspector or any decision maker must consider the specific individual impact of the development that's proposed.
Yes.
So in order to be inconsistent, in order for the council's decision making to be inconsistent, it must be that the council has treated comparable development to this scheme, which has comparable impacts to this scheme, in an inconsistent manner.
I think in this instance the council has these two schemes are comparable in that they are within the Green Wedge, proposing residential development with an impact on the Green Wedge, and the council have taken account in this decision of that balance, and they don't appear to have taken that account in the scheme that we are appealing, and that's the comparison I'm making.
So if we look at the officer report, CD 13.5, and it's PDF 22, it actually says page 82 on the bottom.
22, electronic.
But let's go 21 electronic just to introduce the section. It says page 81 at the bottom, centre bottom of the...
Yeah.
Got it. We see in bold there, impact on the Green Wedge and landscape visual impact and the Green Wedge function. You see that?
Yes.
And if we go over the page, second paragraph, it's in parcel A of the green wedge between Blaby and Glen Parva. And it's the third paragraph on the page I'd like to look at that starts, the proposed development is confined to the northern half of the application site. You see that?
Yes.
Retaining the southern half of the site as open space where flood risk associated with the River Sence places a natural constraint on development, whilst the development would weaken the defensible boundary provided by Little Glen Road to the northern edge of the green wedge. This is the important part I'd like to focus on. The built element of the site would not encroach significantly into the corridor between Glen Parva and Blaby, and in any case no further south than the activities on the neighbouring Glenford Grange. Development of the site would impact on the functions of this part of the green wedge in respect to the merging of settlements and guiding development form. However, the integrity of the green wedge in this area would not be fundamentally harmed. Do you see that?
Yes.
And I think in terms of the assessment of harm by the council, you were here for Mr. Collins's evidence last week.
Yeah.
That the effect of this scheme is to tip the policy, the green wedge policy along the Lutterworth Road edge into a failure point where the settlements have merged. You recall that?
Yes.
So, on the one hand, we have a scheme that is, on the council's case, fundamentally prompting CS16 to fail by merging the settlements. And in Glen Parva, it's noted that the integrity of the green edge would not be fundamentally harmed. So one says it will be fundamentally harmed, the other says it won't be fundamentally harmed. We're considering wildly different impacts on the green wedge, aren't we?
Not wildly different, no. There's the, as it says there, is the northern half of the site. So half of the site is being developed. A significant, in that context, incursion into the green wedge. Here we've got 35%, 65% of the site is undeveloped in the appeal scheme. And I've also referred in the in paragraphs 518 to 520 about the elements of the distances, the retention.
We're going to come to that in a minute.
The retention of the space of green wedge and how the green wedge that's retained is lesser in the instance of Glen Parva. So on a smaller development, its residual green wedge is smaller.
Your Appendix 7, PDF 72.
Yeah.
That's the illustrative layout for the Glen Parva scheme, isn't it?
It is.
And what becomes plain from that image is the extensive built form, as noted in the officer report, doesn't go any further than the neighbouring development on the east on Little Glen Road.
Yep.
And so, again, in terms of where there are similarities or differences, this is not going any further than existing built form versus your scheme, which extends into the green wedge from the southern end of the Davidson scheme, joining up with Rose Business Park. Again, fundamentally different considerations.
Well, it joins up with the business park in terms of the red line of the development. There is, as I mentioned earlier, a significant landscape buffer between the business park and there's the corner of the southwestern corner of the site where the open space is wider. So,
and then at your proof 5.20, this is where you introduce this measuring of boundaries.
yep,
So we can see in your figure 4, we've just looked at the illustrative layout for the Glen Parva scheme. We can see at your figure 4 the existing development on the right hand side, can't we?
yes,
If you look in the Google image view, just by the red marker is the existing development that sits next to the
Yes.
scheme. and the appeals scheme would go into that field just under the annotation Little Glen Road, extending no further south than the existing built form to the east.
Yes.
And you've measured the distance there from the built form as proposed to the edge of Glenparva, Blaby. That's your white line, that's your metric.
That's correct.
Right. Sorry, it's Countersthorpe, isn't it? Forgive me. Firstly, there's nothing within policy that says that measuring the gap is some form of determinative consideration. It's a matter of judgment with regards to the open.
Yeah, I've used it as an indicator.
Visual spatial. And the gap which you compare it to, if we look at your 520 and the measurements that you take, is comparing it to the Winchester Road side of the appeal scheme.
Yes.
And as agreed by Mr. Collinge and Mr. Holliday, that's the least sensitive part of the area of separation that this scheme impacts.
Yeah.
You don't measure any effect at all on the most sensitive part that this scheme affects, which is Lutterworth Road.
No, I haven't. However, I think in that, as discussed yesterday and previously in the inquiry, the western side of the site, whilst the green wedge policy designation overlays the area, there is already significant development along that Lutterworth Road. So there's already a diminished gap in terms of the green wedge in that location on that side.
One of the points that Mr. Holliday agreed is that where one has a diminished gap, and on Lutterworth Road, that's through the pressures from built form that have been consented. There are still parts of that gap that are protected by green wedge policy, aren't there?
There are.
Which would include the appeal site.
Yeah.
Which would include the appropriate use of the rugby pitch, issues around the buildings, whether they're small scale or not, but the pitch itself.
Easy issues to dismiss, maybe. They're not easy issues to dismiss. That the rugby club itself, whilst the pitch is open and an appropriate use within the green wedge, as acknowledged within the committee report for the rugby club planning application, the buildings of the rugby club exceed that which would be acceptable for those leisure uses.
Even if we take that as your case and expect to accept that, the rugby pitch itself remains an appropriate use within the green belt, forming
it does
green wedge.
Yeah.
You'd think by day 6 I'd stop that slip by now. There we go. Which serves part of the function of separating settlements and providing the green lung and the recreation resource, yes?
Yeah.
And on the other side, the rugby pitch, the golf course, which again provides a sense of separation, yes?
Yes, not a strong sense of separation.
And a recreational resource.
A recreational resource and non-compliant uses.
And so, whilst there is built form that extends down Lutterworth Road, you still have these protected areas that are still performing a function in accordance with the policy, and therefore become more sensitive as the last vestiges in this location, don't they?
No, I don't necessarily think they do, because you need, in terms of the effects, it's contextual. As go over all the evidence from the previous days, but the feel of going up Lutterworth Road from Whetstone to Blaby is you've arrived in Blaby before you get to the green wedge, before you get to the golf course. You've got the business centre, you've got the commercial uses on the western side of the road coming up, the garden centre, the kitchen centre, the office building, you're already in Blaby. So, yes, it's designated as Green Wedge, but the feel of it is not Green Wedge.
If the inspector agrees with Mr. Collins that the development of your your client's scheme would result in a failure point of the CS16 policy between Blaby and Whetstone in this location on Lutterworth Road, a failure point of the policy, that's a very important consideration when it would come to attaching his weight or applying his judgment on the weight to that conflict, isn't it? The fact a failure point is reached. I know that's not your case, but I want to understand how, as a planner, if the inspector were to agree with Mr. Collins that the failure point is reached along Lutterworth Road, that's a very important consideration that goes to weight of conflict.
Well, you wouldn't have the balance consideration if you hadn't failed that element of the policy. You don't need to invoke the balance element of the policy if you haven't already had an impact that you might deem not acceptable. But if you read the policy, it says...
No, this is before, because you have to do the internal balance, and I accept that, and the substantial weight's agreed that goes into it. But the inspector's going to have to perform that internal CS16 balance, isn't he? Which is going to mean identifying any conflict with the policy.
Yes.
And then weighing it against the provision of market and affordable housing as the terms of the policy set out. So on that first part of that exercise, if he agrees with Mr. Collins that the policy reaches a failure point in this location, i.e. the settlements of Blaby and Whetstone are merged, that's a very important consideration when coming to look at the harm side of that equation.
It doesn't take on additional weight as a very important consideration. It's a consideration that you have to take. Because if you hadn't breached that first stage of the policy, you wouldn't have to go on and do the balance. You'd met the policy. So it's not, you don't say, oh, actually, I give that extra weight because I've failed the first bit of the policy. It's just the natural next step. So it's not, I wouldn't say it's a very important thing. Clearly, it's a consideration you have to do in applying the policy.
You reference a number of other appeal decisions or council decisions as part of this ongoing point about inconsistency of application of CS16. 5.27, you mentioned the Littlethorpe appeal.
Yes.
Whether we need to go there or not, the Littlethorpe scheme was not in the Green Wedge, was it?
No, it wasn't.
So in terms of considering how consistent or inconsistent the council's been or an approach to determining compliance with CS16, it doesn't help at all because CS16 wasn't in dispute.
Well, except that it's adjacent to the Green Wedge.
Right.
That was the point I was making.
Do you apply Green Wedge policy in sites that are adjacent to the Green Wedge?
No, but it has an effect on, as I've shown on the images of after 528, figure 6 of my proof. So the Littlethorpe scheme is the area of land just to the west of the Green Wedge, but it does have an effect of lessening that Green Wedge because it elongates the existing settlement there. So I think it's a relevant consideration. It's notable.
There's a number of other schemes mentioned in your, or decisions mentioned in your appendices. If we could just pull that table up, please. Spend some time of it there. Appendix 10, which starts on PDF 77. There's then the plan on 78.
Yeah.
And then the table that you produce on over the page, you see that?
Yes.
So looking at going back to the points of agreement earlier, that in order to be consistent, one has to be looking at development in similar locations with similar effects to see how the council has approached them. If we start with land south of Warwick Road, we can see, can't we, in your copy from the conclusions of the committee report, that the site already benefited from a scheme for 31 dwellings. See that?
Yeah.
And the application was for 15 more on the site.
Yes.
And as you very fairly note within the second column, it's only the parts of the site within the green wedge that are used for access and attenuation ponds. So no further built form being proposed within the green wedge.
Yeah.
And of course, you are proposing built form in the green wedge, that's why we've been here for so long.
Yeah.
Insofar as the effect of the suds ponds and the access on the purposes of the green wedge, if you go down within that box to the penultimate substantive paragraph, which starts the green wedge strategic review, you see that?
Sorry, where are we looking?
If you, the second paragraph, the penultimate paragraph from the bottom of the box that's dealing with the Warwick Road scheme, it starts, the Strategic Green Wedge Review 2009 states that the effectiveness of the green wedge to the east and southeast of Littlethorpe is questionable. It offers very little in terms of recreation through the access, although access can be gained informally via gaps in hedgerows, and there are some desire lines. You see that?
Yes.
The green wedge assessment, which we've spent a number of time in, sees the green wedge along Lutterworth Road between Blaby and Whetstone as essential, doesn't it? So there's a fundamental difference in how the green wedge is performing in locations between here and between the land south of Warwick Road.
Yeah. As you mentioned earlier, every site's going to be different, but the purpose of including these sites is to demonstrate the situation the council are in of needing to look to their green wedge to meet their housing need.
And I think that's accepted, but what these other decisions don't do, and let's see if we can agree this, it might short circuit things, is say that all development is going to be acceptable within the green wedge.
They don't do that, but they indicate that in accordance with the policy there is circumstances where development is accessible.
Nor do they have similar comparison or enough comparison points to say that had the council been consistent, this scheme would have been granted within the green wedge.
They go to the position the council are in needing to weigh that balance that's
yes,
within the policy.
Which we've discussed in terms of weight to CS16, and we've discussed in terms of the weight to the housing that goes on one side of the balance.
So there are examples of where the council has made that balance, and in our view the council haven't sufficiently weighed the balance appropriately in this instance.
I think we have to look at these then, unfortunately. If we look at the Abbey Farm one next.
Yes.
This was for the reuse of existing, we can see third paragraph down that starts, the application proposes the reuse of existing abandoned buildings to provide 6 new dwellings. You see that?
Yes.
So it was already proposing housing on a site that already had built form. Fundamentally different to the proposal here.
Yeah, it's a small scheme it's got, but again, I'd say it's in the table because it's a relevant scheme in terms of what's happening in the green wedge.
And the conclusion ultimately from the officer was that because it's a reuse of derelict buildings that are already within the green wedge, there was no harm to the CS16 policy.
Where's that?
The proposals are considered to meet the criteria of CS16, and it is therefore considered the proposal would not be harmful to the functions of the green wedge. You see that? The first sentence over the page.
Right, yeah.
So the council doesn't even get on to doing the balance of harm to the green wedge against the delivery of housing, does it? Because it says there's no harm. Agreed?
Yes.
And even on your case, you accept there is harm to the spatial element of the open and undeveloped character of the green belt.
Yep.
Someone needs to change the name of this policy, the green wedge. Thank you. North side of Grove Road, Blaby. The first paragraph sets out the tests of the policy. When considering this current application, the green wedge also recognises the need to retain green wedges should be balanced against the need to provide new developments in the most sustainable locations. So the balance was applied.
Yeah.
And then the conclusion of officers is that the development of this relatively small scheme will not significantly harm the wider green wedge, nor its primary function in this location as providing a green barrier that prevents the merging of the two settlements of Blaby and Whetstone. The built form will not extend beyond the westernmost extent of the existing residential dwellings on the opposite side of Grove Road, and there is still retained undeveloped land leading up to the Blaby bypass. You see those conclusions?
Yes.
So again, fundamentally different to the position here, which is a complete closing of the gap along the east of Lutterworth Road.
What that's saying is that there is an impact on the green wedge, and the council have applied as their policy and the reason justification that I pointed to earlier on the policy that you don't. Can I get the policy up? In terms of the purposes and the functioning effectiveness of the green wedge, 716.3, to consider the green wedge to be functioning effectively, it needs to be fulfilling one or more of the functions. So in this instance, they've looked at those functions and they've said, well, we can have some impact. And that's the case we're making here.
The reason you're relying on these is inconsistency of the council's approach, not your approach, the council's approach. That's what you agreed with me earlier.
Yes.
And so one has to look at how the council has approached and applied this policy, this CS16 policy.
Yeah, and that's what I'm saying is that they have applied the policy and they haven't.
If you wait for the question, the point of difference here is the level of conflict with CS16. The council's level of conflict in this case is it's reached a fundamental failure point in this location. The council's conclusion of conflict in north side of Grove Road is it wouldn't significantly harm the wider green wedge nor its primary function of providing a green buffer merging the two settlements for the reasons given. So in terms of a comparator, again, this doesn't assist the inspector at all.
Well, in the council's view, and it's an example here of where the council has taken the view that the development can accord whilst having an impact. And what we're saying is that the degree and weight of impact in the appeal scheme doesn't meet those trigger points on this side of the site anyway.
Glen Parva we've looked at, and the last one is the rugby club, which I think we touched on with Mr Collinge in his evidence. And you see there, the members felt that ensuring the continued use of the Leicester Lions Rugby Club outweighed the impact of the development on the green wedge in this instance. So the specific considerations in that scheme were the needs of the local rugby club.
Yes. Yeah, those were the members' view. Obviously, the members take the view of the council. It wasn't the officers' view.
Yes, indeed. But it's a fact that the balance has been exercised and they've reached a conclusion. Yeah. And I don't think the council is saying that the inspector shouldn't take a balance when looking at CS16.
No.
Is it? So in terms of being consistent or inconsistent, the council's taken the balance in CS16 in Leicester Lions, and the council's suggesting the inspector should take the balance in this scheme as well. We just have a different view on where that balance falls.
We do.
So the council's been consistent.
Well, I'm not sure they have been consistent because they've not consistently applied their view of the weight.
Is the difference between us you just don't like the council's decision on how it's applied the balance? Because the fact in terms of its application is consistent between Leicester Lions and here, where we're saying to the inspector apply it now, and it was applied in Leicester Lions. No difference. You just don't like the conclusion.
No, because I don't think the actual balance has been addressed.
Right, I want to look at the other tests in terms of B and C within CS16. I don't want to rehearse Mr. Holliday's and Mr. Collinge's evidence, but I want your view as a planner in terms of how the inspector should apply that evidence to the tests that are given in policy. So B is retain and create green networks between the countryside and open spaces within the urban areas. You see that?
Yes.
So we can accept, can't we, that you don't need to give the ordinary meaning of words with the application of common sense, etc., etc. Yes?
Yes.
Right. Retain means keeps what is already there.
Yep.
And create means make something new.
Yes.
Right. And then we need to look at what new thing, well, we can agree that you're retaining the footpath links that are already there across the golf course and across the northern edge of the site.
Yeah.
So the retain element, I don't think there's any dispute between us. The issue is the creation of new green networks between the countryside and open spaces within the urban areas. Have you got Mr. Holliday's appendices again? And it's the plan we've been to a number of times. It might be in your appendices as well, actually. Figure 18. If you have figure 18 and the wording of CS16 in front of you.
Yeah.
So we need to look for new green networks between the countryside and the open spaces within the urban areas.
Yeah.
So the footpath Z56.5 that provides one of those links in 67.1 and 56.4, the new provision you're providing is internal to the red line boundary.
Sorry, say that again.
You are providing new accessible green space within the appeal site, and it's annotated potential new footpath links, which is a walking route within the scheme.
It is, although it links. So the green, was it green or dark? Is it black? I don't know. The darker coloured dotted lines within the site are annotated in the key as the potential new footpath links. So some of those link directly to the existing paths. Some of them link to external areas. So there's one that goes to the northeast that comes out opposite the reserve allocation. So that creates a new link to the roadway to the east of the site.
So the new link that you're then presumably relying on is that one that runs onto Winchester Road, which we spoke about in terms of the removal of hedgerow.
That's not the sole one, because there's a new link internal to the site to the existing footpaths.
Which is the access to the scheme.
Sorry, no.
Which is the access to the scheme, isn't it?
Sorry, no. We're connecting to the existing footpaths within the site, and they form part of the existing green network that you're referring to, and we're creating new networks within the site that link to those. So it doesn't say you need to create new networks. That within the site will be part of the countryside.
And in terms of the test C, again, retain the same meaning, enhance a different word than create. So enhancement we can take as meaning improving the amount of access to the green wedge, especially for recreation.
Yes.
And we can also take to mean improving the quality of access
Yes.
into the green wedge for recreation.
Yeah.
We know that the public already has access to the green wedge in this location because of the footpath that crosses the golf course.
Yes, limited access.
And it's patently obvious, but with the addition of the public open space, there will be more footpaths available to the public to walk through this part of the green wedge.
Yeah, well, there'll be no restriction on the access. So it won't be that the people accessing this area will be constrained to the footpaths. I mean, there's
Yes.
a country park, the Canterthorpe Country Park would be, you know, akin to this area that's being proposed, and the inspector will go there, presumably on the site visit. There's footpaths there, but you're not constrained to the footpath. You can walk across the field. You know, there's ponds in there. You can walk to the pond.
And so when we look at enhancement, yes, improving the amount. There doesn't seem to be a point of disagreement.
Yes.
But the inspector, as you said, also needs to improve the quality. And one thing that the inspector must take into account as part of that assessment is that to access the same piece of green wedge that is currently publicly accessible, users will need to go through the built development of 200 units as proposed by your client.
No, they won't necessarily. There's the existing route through the access point from the east. So,
but we know from your surveys that the most likely route is going to be from that northern footpath and down, and you'd say to access that public open space in the corner.
if you're coming from the north, if you were coming from the south, okay, so currently from that survey we know there are people who are using the footpath along the northern perimeter of the site. They may be people that are going to Canterthorpe and they may prefer to walk across the northern part and then all the way down rather than cutting across the golf course so they don't want to get hit by a golf ball. So,
well, they may
but equally, they may, and the survey showed that people are moving the other way as well, so people are coming up from Canterthorpe. So, it's you know, we don't know how people will use this space, but there is no restraint, and there will be opportunities for people from Canterthorpe who want to go to Blaby, or actually just want to go and have a walk or a run or do whatever they want with their kids, to go into this space from the south.
And those, of course, living in north of Canterthorpe, as we can see from Mr Holliday's plan, have access already to the Canterthorpe Country Park area, 9.5 hectares there.
They do, it's about additional choice.
And with regard to your own survey of the footpath usage, the most commonly used route is the Z56.4, Z67.1 that runs along the northern boundary.
Yeah.
And therefore, from the evidence that you've produced, the most likely route that people will take into that public open space area is through the built form, on the evidence you've produced.
Well, we don't know where the people coming from.
Well, let's deal with what we do. Let's deal with what we do know. We do know, on your evidence, that the most walked route is that run along the northern boundary.
We do.
And we do know that in order to access your public open space from that northern boundary, then the most likely route is going to be down the 56.5 through the built form. Or is it your case that they'll walk all the way along, down Winchester Road and then back in the entrance?
No, what I'm saying, so you're talking about people accessing from Blaby from the north. All I'm saying is there will potentially be people, and the survey at the moment shows there are people coming into the site from the east who could be either coming from bits of Blaby at the east or bits of Canterthorpe from the east. There's movements both directions. You're inferring that all the movements are only from the north.
No, I'm just relying on your evidence, Mr Custon.
Yeah, and that's, I think, what I'm saying the evidence shows.
I want to move then on to the...
It's two-way movements.
Absolutely, I mean, there's no prohibition, is there? But the evidence you've produced is that it's the northern route that's the most well used.
Yes, in two directions.
Right, let's move to the golf provision, please. Do you have the framework in front of you?
I do, yes.
104, please.
Yep.
You'd agree with Mr Smith that when looking at open space, sports and recreational buildings on land and whether they are shown to be surplus to requirements, in terms of 104A, the inspector needs to consider the 9-hole, the pitch and putt and the adventure golf course. want to take it in stages?
Yes.
So firstly, you rely on Mr. Smith.
Yes.
Mr. Smith accepted yesterday that the 9-hole course is a sport building and land for 104A, for 104 purposes, and that the pitch and putt and adventure golf are recreational
right,
buildings and land. So all three are covered by the policy. You accept that?
Yeah.
Right. Therefore, when the inspector comes to look at 104A, an assessment has been undertaken which clearly shows the open space, buildings or land to be surplus to requirements. It needs to be that the 9-hole course, the pitch and putt and the adventure golf are surplus to requirements.
Yes.
Thank you. And we can see, can't we, from the wording of the policy, an assessment has been undertaken to show that it is surplus to requirements. Now, before my learned friend makes submissions on it, there's no burden of proof in planning inquiries, etc., etc. But the wording of the policy, an assessment to show that it is surplus to requirements, is something that falls upon the appellant.
Yes.
Thank you. We've had some debate around this issue of timing, you'll recall from Mr. Smith yesterday, for the Davidson scheme. Do you recall all of that conversation?
Yes.
Davidson's is an outline consent, isn't it?
It is.
And there is no reserve matters application in place.
No.
There are pre-commencement conditions on the consent.
Yes.
And there's likely to be further conditions on any reserve matters approval.
Yes.
And obviously, before building can commence, they need reserve matters and they need the pre-commencement conditions discharged. Yes. And so it's fair to say then, isn't it, that the Davidson scheme has cleared the first hurdle in terms of starting.
Yes.
But they've got a number of obstacles still
Got further
remaining.
work to do, yes.
The point agreed yesterday with Mr. Smith was that the effect of an appeal dismissed world, so the inspector dismisses your appeal, is that that would be a material change in circumstances when looking at the Blaby versus Enderby golf course dispute. Do you recall that part
Yes.
of his evidence?
Yeah.
Because you'll agree then that the effect of dismissing the appeal would be to protect Blaby as not being golf course, as not being surplus to requirements.
I can't predict the decision the inspector might make, and it may be that it might be determined that 104 is met, however, the green wedge isn't. So
that's a very fair point, and I should be more precise in my questions. If the inspector concludes that the scheme fails 104A, and for including other reasons, potentially the scheme is then dismissed, the effect of that form of decision would be that Blaby Golf Course is protected as not being surplus to requirements.
yes.
And as Mr. Smith agreed yesterday, nothing's certain in planning until things are being built, but that would be a material change of circumstance where the direction of travel favours the allocation of Enderby Golf Course through the local plan process.
Yes, you've mentioned the hurdles for Davidson's, the redevelopment of the Enderby has considerably more hurdles yet to take.
Absolutely, and I'm really keen not to overstate positions, because Davidson's we've been through, an emerging allocation needs to go through Reg 19, further consultation and examination.
Yeah.
The strategy may change, examinations reveal all sorts of different things, developers promote different sites. It's a long way off adoption. But the direction of travel is towards...
It would put the focus back on Enderby.
Yeah.
Yes. It would be a very lengthy process, though.
Yeah, I mean, it might be on the new, I know it's not, it depends when it's submitted, whether it will be on the new speeded up local plan process, but that's a debate for a different time. And you agree with the points that have been agreed between the golf experts that the likely effect of appeal dismissed world is that there would be some shift which would increase over time, leading to Enderby closing, of the got some golfers from Enderby to Blaby.
Yes, I don't think there was any agreement over the timing of all
No,
of
there
that.
wasn't. That's right.
The principle that if, as accepted, one of the two golf courses can go, the consequence of one of the two going would be the other one would be busier. But the timing, in terms of the effects on Enderby, is a significant factor,
Yes.
because whilst, as you say, Davidson's have got further hurdles to do before potentially impacting on the golf course at Blaby, as we've talked about, that, in my view, would happen a lot quicker than the closure of Enderby and any uplift in trade at Blaby resulting from the closure at Enderby.
In your view, the Davidson scheme would happen a lot quicker. You're not part of the team that's promoting that scheme, are you?
No.
You've not been discussing with Davidson's when a reserve matters application might be forthcoming?
No, but it's controlled by the timing on the consent. It will have to come forward within the terms of the conditions on the consent,
Yes.
which I think, in my planner's view, is likely to be quicker than getting an allocation, then doing any applications, then further reserve matters and implementation of anything that might happen at Enderby.
Thank you. Right. I want to look at 104B.
Yep.
And the quality and quantity being equivalent or better, and agreed in chief, agreed on this side, matter of planning judgment, open textured. This isn't a case of measuring the size of the golf course and seeing if your football pitch is the same size.
Yep.
It's an open textured judgment for the inspector.
Yes.
But in considering what is equivalent or better, one needs to take into account what is currently available on the site.
Yes.
And currently available, as agreed earlier, the sporting provision of the 9-hole golf course. Yes?
Yes.
And the recreational provision of the pitch and putt scheme.
Yes.
Now, you're relying on Mr. Smith for the quality of the current scheme,
Yes.
of the golf course.
Yeah.
You're not saying that from a planning perspective, a 104B perspective, we should assess quality differently to the ANOG guidance that we've been through and to the conversations we had yesterday.
No.
And so for 104B purposes, one is still looking at meeting users' need as one of the key functions that goes into measuring quality. You heard that conversation yesterday with Mr. Smith.
Yes, I don't think there's agreement as to how well that quality does
No.
meet people's need, but yes, it's a consideration.
I should have put it a different way, it would probably been a lot easier. You're not saying that when one looks at quality for 104A purposes, we do it any differently to the way, at 104B purposes, we do it any differently to the way Mr. Smith looked at it for 104A. It's the same.
No.
Thank you.
Because Mr. Smith is advising on the quality, and it's that quality that's been taken into account. You know, it's a qualitative and quantitative decision in terms of B, isn't it?
Your brief, you cite the Horsham case.
Yeah.
So you cite it in your brief. Forgive me, I've lost the paragraph. 4.42. And you cite it and say the Horsham Golf Club appeal, in which the inspector gave significant weight to the improvement of other sporting provisions as part of this consideration of equivalent or better.
Yes.
Right, let's just look at the Horsham decision. CD 10.2, please.
Okay, I've got it.
And we can see, can't we, as usual, fourth bullet point under the heading, introducing the appeal, the description of development. See that?
Yes.
Now, it is a bigger scheme, it's 800 units, which you can see from the end of the description of development.
Yes.
But this is a scheme that also proposed a sports and leisure hub, including the provision of communal facilities and the nursery. I'm not sure whether they were considered to be sports and recreation, so I'll leave those out. But a golf college, a sports health club, clubhouse containing health and fitness, spa, changing facilities and food and beverage, an educational facility for Warren Clark, Golfing Dreams, open space, outdoor sports and leisure provision comprising driving range, re-provision of golf, including supporting golf facilities, and hockey, including pitches and training areas. You see that as part of the
Yes.
proposal.
Yeah.
So significantly more sporting provision than being offered here.
Yes, as you say, bigger site, bigger development, more houses.
So in terms of the utility of this appeal decision, are you only relying on it insofar as it shows you don't have to replace golf with golf?
That's the point we've made on here. You don't have to replace like for like,
Yeah.
And it's about the. And we've made the case in terms of the quality and quantity of provision being made in our instance.
Well, if that's as far as you go with this, then I think we can agree. In terms of what is being provided, there's a 10.5 hectares of public open space, which you've discussed and Mr. Holliday have discussed at length. This is not in and of itself a provision for organised sport, is it?
No, the organised sport element is the football pitch.
And we'll come to that in a moment. One of the other mechanisms that you rely upon is the HACT tool. You call that from your proof. And that measures, or pertains to measure, the value of the public open space and sport and recreation provision being provided.
Yes.
Which is Mr. Cook's report you
Yeah.
went to in chief. There's no assessment undertaken by Mr. Cook of the baseline value of the appeal site, is there?
I don't think he's applied that tool to it, no.
So in terms of assessing whether what is provided is equivalent or better, which we've agreed necessarily involves a comparison with what's currently there, Mr. Cook's assessment doesn't really assist in that, does it?
His assessment gives us a value of what's being proposed, and it weighs into the overall balance. In terms of the equivalence and the quality and quantity that's being provided.
And we're going to come onto the football pitch in a moment, and parts of the public open space. But starting then, just continuing with what's currently on site, National Golf Governing Body, Golf England, objecting to the scheme. Starting point as the national governing body to such an objection would be significant weight.
I don't think it is significant weight. I think yes, you'd give weight to that objection. However, they are, as we heard yesterday, they're an interested party. Their job is to protect golf clubs. They're going to say they don't want to lose this golf club.
But we know, don't we, from Mr. Wright's evidence that they don't object to the loss of every golf club.
Yes.
And so the fact that they've objected to this application on this course is a material consideration of significant weight.
I don't know how many golf courses they object to and a proportion of cases that they object to. I think it's a material consideration of weight. I'm not sure that it carries significant weight.
I want them to look at the football pitch and the consultation response on which you rely, please, CD 3.12. That?
Yes, I have that now.
So we see at the top, consultation response for playing pitch provision from the sport and physical activity team at BDC.
Yes.
And we see there in italics, that's the scheme that's under consideration by the inspector. And then it sets out the methodology using the PPS, the playing pitch strategy. Yes?
Yeah.
And the playing pitch calculator, which
yes.
Again, yes? Which you accept is an appropriate methodology
yes.
for calculating.
Yeah.
And the volume additional provision required and estimated demand. Now, hopefully we can agree this, that the way one applies the PPS and the playing pitch calculator is to look at the number of homes, the number of people, and therefore see what the demand for sporting provision will likely be.
Yes.
And we can see at the foot of electronic page 2, the final paragraph, there's a growing demand for 3G pitches. There's a current deficiency of 3 pitches outlined in the update e-documents, council's own evidence, with this development requiring an additional 1.27 hours of training per week and an artificial pitch for football, as shown in table 2. And therefore it makes recommendations for contributions to 3G pitch development.
Yes.
You see that?
Yeah.
So the recommendation is that the contribution to 3G pitch development is meeting the demand that's forthcoming from the scheme.
Right.
Agreed?
Mm-hmm.
Going down to suggested projects over the page. There is a shortage, council accepts, of 11v11 football pitches in the Blaby East area, you see that?
Yes.
And they're overused by 1.5 equivalent matches. And then the calculator is applied. With the conclusion over page. And the consultation response says, just above rugby union, therefore further grass football pitch provision for youth football, 9v9 or 11v11, so either a 9v9 or 11v11, I think you're proposing 11 and 11.
Yeah, yeah.
Is required to meet the demand of this development.
Yes.
You see that?
Yeah.
So again, the conclusion is that this is necessary to meet the demand that this development will propose.
Right.
Agreed?
Yeah.
It's not going over and above meeting that demand because it is, as set out there, required to meet it.
Right.
You agree?
Yeah. But it's part of an overall package that's being provided.
Yes, but if this, let's look at it another way. The requirement to meet the demand is independent of the 104B assessment of replacement of equivalent or better, isn't it? So if I put it this way, if this scheme wasn't on the golf course, but was the same size in a similar location, you'd still need to produce an 11v11 football pitch. Because the loss of the golf course doesn't factor in at all to determining what you need to provide to meet your demand.
No, and equally there's within the PPS there's no the golf doesn't come into the standards that the council apply and the nature of space that they look for.
But
so
let's take this in stages then. You'll agree with me that the loss of the golf course doesn't factor in at all into calculating what is required to meet the demand produced by this scheme. The PPS, the calculator, is independent of the loss of the golf course.
Yeah.
And so when it reaches a conclusion that you must provide a football pitch, 9v9 or 11v11 to meet the demand of this development, that is the case whether you're on this golf course or not, because the golf course isn't a factor.
Yes. But it's, as I say, the judgment for 104B is about the overall package, and they do form part of the football pitch, in my view, forms part of that package.
But if you're required to deliver this, irrespective of the golf course, you're not providing anything over and above what you're required to do by policy.
We are, because we're providing the wider package.
So the wider package that you're relying on then is the above policy compliant public open space.
And the other, I've listed the benefits.
Okay, well, let's come to those other ones then, because it's in the same consultation response. If you, under rugby union, the officer goes through the same approach, PPS, calculator, number of people produced by this scheme, what you're required to do to meet that demand.
Yes.
That's the methodology that it applies, agreed?
Yeah.
And you accept that's the appropriate methodology?
Yes.
Right. And again, artificial grass pitches and cricket, same methodology, current supply, production,
Yes.
demand. Right. And the recommendation at the bottom then is in the summary of suggestions, you see that?
Yeah.
Football pitch, contribution to 3G, contribution to Oakfield Park, and improvements at the cricket wicket at Northfield Park.
Yes.
Are the recommendations to meet the demand of the scheme?
Yeah.
Again, independent of the loss of the golf course.
They are, but I think, so in terms of applying policy 104B, the loss, the recreation space should not be built on unless the loss resulting from the proposed development would be replaced by equivalent or better provision. In this circumstance, so it comes back to the principle that we're looking to develop to meet a housing need. We've seen the council are in a position where they're looking, that there are limited opportunities, I think it's acknowledged, to develop new housing outside of the green wedge, or outside, and so we're in a situation where we're looking for the most appropriate locations to deliver that within the green wedge. This golf course is acknowledged as a sustainable location on the edge of Blaby. We've seen all the other policies that we're meeting in delivering it. So then you say, well, okay, however, it's a golf course, so we're going to lose the golf course. Can we justify losing the golf course? And in order to justify it in this policy, you look at, are you providing equivalent or better provision of sports and recreation and open space facilities? And the answer to that is yes. The fact that some of those elements are also policy requirements that will be delivered if you were able to develop in another location doesn't demur from the fact that you are actually addressing the loss of the golf course. Because if you didn't, or because there's not another location to bring forward, you know, this is an appropriate location and you're able to mitigate the loss of the golf course by the fact that you're delivering those open spaces and other recreational space. So it's doing two jobs. It's meeting the policy requirement of CS15, but it is also addressing 104B.
Thank you. I just want to look as well in terms of the effectiveness of what is being proposed. The PPS, please, CD 8.7.
CD, sorry.
8.7. And it's PDF page 84, sorry, 124. Paper page 123.
Yeah.
And we're in part 15, the housing growth. So looking at how playing pitch provision should link to housing growth. You see that?
Yes.
And the second paragraph, experience shows that housing sites with 600 dwellings or more are likely to generate demand for new provision to be created. Just pausing there, this isn't a scheme of 600 dwellings or more,
No,
is it? No. But you agree with the consultation response that at 200 units you've generated demand for new provision to be created.
Yes.
It then goes on to say that you should look to consider multi-pitch sites with suitable ancillary provision, including appropriate clubhouse changing facilities and car parking, and concluding that single pitch sites, which have been provided traditionally by developers, are not considered to provide long-term sustainable provision for the relevant sports. Do you see that?
Yeah.
So you've created a demand which puts you into the same consideration as these larger schemes.
But not the same scale of demand.
But obviously there's fewer houses. But there's debate within the PPS, as seen here, about the effectiveness of single pitch provision, isn't there?
There is, in the context of those larger schemes, there's no debate within the consultation response from leisure services who've asked for the football pitch. They haven't asked for those attendant other facilities, and it's common ground that is what's being asked for and being delivered.
In terms of access to the football pitch, I don't think there's any detail on it, so I'll test your view. Is it going to be free to use, or is it likely to be pay to play?
I don't think that detail
No
has
control
been,
on it.
but I don't know the answer to that, I'm afraid.
So
but there's no indication in any documents. There's nothing before us to say it would not be free to use.
Yes. Or that it would not be paid. We don't know either way.
We don't. But I would suspect it's a request that the council have made. Whether the council then manage it or not, I don't know.
So taking those sports provisions and the response to the consultation response, the pitch, Holmes Park, Oakfield Park and Northfield Park, as you said in your longer answer before, are required within the terms of CS15 as
Yes.
part of the mitigation of the demand of the scheme.
Yeah.
And so a failure to provide those would be a breach of CS15. The same must be true. If they're required by CS15, not giving them would be a breach of CS15.
They're part of what the council have asked for in respect to CS15 in that consultation response.
I want to look at the 100 grand, please, to golfing. Have you got the 106 in front of you?
Yep.
So I think I might be on it might be an older version of the 106. Do you find the golf facilities contribution within the definitions?
Yeah, I've got it here at hard copy page 13.
Thank you. Which is the sum of £100,000 index linked payable by the owner to the District Council towards improvement to golf facilities within a 20-minute drive time catchment area of the application land.
Yes.
So the offer is for £100,000 to any golf facility within 20 minutes of the scheme. That's what the 106 says.
Yes, payable to the District Council.
This 106 isn't restricting it to Enderby Golf Course.
No.
And the 106 doesn't say that it has a specific use at any of the golf courses within a 20-minute drive time catchment.
It's not specified, no.
So that I can understand this £100,000 figure, what document do I go to that tells me how you've calculated the 100,000?
I don't know that.
There isn't any evidence
there's
of how you've
nothing
calculated
no.
100,000. Right. So it's a figure, for all we know, plucked out of the air, because we don't know otherwise.
Well, it's a figure that's been offered by the developer based
Based on nothing.
well, the anticipated expectation of what might be a reasonable sum for enhancement of golf facilities.
Let me turn it around the other way. If the consultation response from the Sport and Leisure officer had said, we want X figure to be used within this large catchment area for something that isn't identified, would your advice be to your client, just it's still compliant, just pay it, or would you be disputing the figure? I don't know if your client sat behind you or not, but they'll be interested to hear what the answer to this might be.
If the council were asking for a sum, I would, as a planning consultant, say, what's it for?
Of some, without any
And how is
evidence
it
of how it's
calculated?
calculated, or without any evidence of what's to be spent on.
But those questions haven't been asked by the council.
They've been made clear in the reason why the council says it should be taken out of the 106 obligation. It's not still compliant.
But, as I said earlier, I addressed it earlier in chief, that I consider it is civil compliant because it's a contribution that is mitigating an impact and arising from the development. It's relevant to the development. We're potentially developing on a golf course. We're offering a mitigation through a golf contribution to enhance golf provision. So,
one of the tests, of course, is it must fairly and reasonably relate in kind to the development. The way one establishes whether it's fairly and reasonably related in kind is by a form of calculation to arrive at a figure, isn't it? Typically.
it hasn't. The council haven't.
We don't want it. we think it's not still compliant. It's your offer. I want to understand why you say the inspector should take it into account as a material consideration.
Because it is a sizable sum that will mitigate an effect of the development.
But
and it would go to, we heard the other day about potential measures that could improve, for instance, the drainage at Enderby. So £100,000 would make a considerable difference to whatever is required to pay for that drainage.
Let's draw it to a close on the point of principle. In order to be a material consideration, as part of the planning obligation, it has to pass the SIL regs tests.
It does.
And it has to pass the policy tests within the framework.
It does.
And so it has to be fairly and reasonably related, necessary, etc.
Yes.
If it fails those tests, it's not a material consideration, is it?
No, it's for the inspector to decide whether it passes or fails those tests. In my view, it passes them.
Your brief, please. And 9.5. So this is in the section, paper page 52, PDF 56, in the section subheaded accordance to the development plan. You see that?
Yes.
So your case, your primary case, as I understand it, at 9.5, is comply with CS16, comply with CS15, comply with the other policies of the development plan, comply with 104, compliance with the development plan overall. That's your primary case, as you put in response to my learned friend. Right. You go on at 9.9 and you cite the Corbett case, which you've cited it, so I'm assuming you've read it.
Yeah.
Where you say at 9.9, if there were a conflict with part of the policy or even one policy in the development plan, this would not automatically lead to it being in conflict with the development plan as a whole. Mm-hmm. And that is in part the principle that comes from Corbett and various other cases that came before Corbett. But you know from Corbett, don't you, that the inspector also needs to consider how firmly the policies are set against any proposal.
Right.
The importance of the policy to the overall objectives of the development plan is relevant. And the extent of any breach are all relevant to this planning judgment exercise of policies pulling in different directions and whether it accords as a whole.
And indeed, whether the policy itself is up to date.
Indeed, all matters of judgment, but factors that must be played into that judgment. So your 9.9, and this according with the development plan as a whole, I just want to understand which scenario you're envisaging here. Is it your position that if the inspector accepts the local authority case, i.e. conflict with CS16 and a failure point along Lutterworth Road, Mr. Collinge's points, the inspector accepts the conflict with CS15 and MPPF 104A, i.e. not surplus to requirements, not equivalent or better replacement. So if the inspector accepts the entirety of the council's case, is your position that it would still accord with the development plan as a whole?
The position on the development plan as a whole is that those policies are out of date, and the weight to be accorded to those policies is lessened by them being out of date. So, in not according with those policies, then the proposal is still according with the relevant up-to-date elements of the development plan. So, it's according with the up-to-date bits of the up-to-date development.
CS1's out of date, CS5's out of date, the strategic guiding development form and the housing requirement out of date.
So we'll set aside the whole of the development plan.
So the point I'm making is that you're sort of imposing this artificial balance of the out-of-date policies that direct development towards Blaby are fine, but the out-of-date green wedge policy, which is out of date for the same reasons, gets significantly less weight. So
well,
I've
referred to in my proof to the wider policies of the plan. There's the BNG policy. There's
yes, we've got your points on compliance, and the council.
There are significant elements of the development plan that we do accord with,
and which the council is not alleging there's any conflict.
Not in dispute.
But I just want to understand your position.
And also CS1 and CS5 are not in dispute.
I just want to understand your position on which scenario you are saying the scheme accords with the development plan as a whole, pulling in different directions, Corbett, etc., which you cite. Are you saying if the inspector accepts the council's case on CS16 and the fundamental breaking of the policy, and accepts the case on CS15 and 104A and B in terms of not surplus to requirements and not equivalent or better provision, so accepts the council's case in its entirety, is it your argument that notwithstanding that, it still accords with the development plan as a whole?
Yes, because the weight of those policies is lessened by the fact that they're out of date, and they're
I think I can make submissions on that. Your section on benefits, lastly, please.
yes.
And a number of points have been agreed, and I'm not seeking to go behind express agreements that have been reached. But I do want to look at a number of the other benefits that are proposed. The first being the replacement employment, your 9.17.
Yeah.
The proposal is that it would port the existing commercial uses into a new building on site. Yes?
Yeah.
There's no new employment space created, it's a replacement for what is already there.
Yes.
So in terms of employment land, one is looking at essentially a net neutral.
So, in terms of commercial development, it's a net neutral. I don't think there's actually, because we've talked about the employment land policy, it's not employment land. commercial development. So I think it's accepted. It's common ground really in terms of what's being like for like replaced.
You mentioned in chief as part of the environmental objective, you give an additional significant weight to providing a large number of homes in a sustainable location in accordance with the spatial strategy, and I won't split hairs to you about whether it's in accordance with the spatial strategy or not. There is, of course, a requirement for development to be in sustainable locations, yes? Mm-hmm. And this is a scheme that is within the Green Wedge adopted policy, yes?
Yeah.
And you are already giving weight to the provision of housing as a substantial benefit, yes? And so the addition of this further significant weight is a form of double counting for the provision of housing, isn't it?
No, the substantial weight to the delivery of housing in terms of meeting the housing need is one element, which is an agreed point. This is a separate point in terms of sustainable development and according with the NPPF and the presumption and the council's spatial strategy. Blaby's identified as a tier 2 settlement in the strategy. This is the appropriate edge of settlement development. It's agreed that it's a sustainable location in common ground. That's where it comes from.
Thank you very much. Thank you, Mr. Cusson.
Mr. Morrison.
Thank you, sir. Can you go to CD 6.11, please, where you started, which is, of course, CS 16. So CD 6.11. And you were taken through the policy by my learned friend. In relation to the strategic objectives, he said to you, and you agreed, that they're not part of the policy. And I think you said to my learned friend, they are the strategic objectives of the local plan, and they tell you why this policy has been included, what its aims are.
Yes.
Can I have your view, please? Is it relevant or not, in your view, to whether the policy is complied with to look at the strategic objectives?
Yes, they're the objectives of the plan.
And just running through them, do we comply or not, this scheme, in your view, with those objectives? So, I mean, the first one is sport and recreation, which we'll probably come to, but that's been talked about by other witnesses. But protect important areas of natural environment, etc., to comply.
Yes.
And over the page, cultural one, comply.
Yes.
Flooding.
Yes.
Transport sustainability.
Yes.
Okay. Thank you. And I think it was also put to you by my learned friend that similarly, rightly, the explanatory text is not part of the policy. What is the role of the explanatory text?
It's what it says on the tin. It's explanatory. It explains how you should interpret the policy. And,
yeah. Yeah. And I think the only part that you really referred to in your evidence was 7.16.3.
Yes.
What does that? Why is that relevant? What does it tell us?
It tells us that, well, to read it out, to consider the Green Wedge to be functioning effectively, it needs to be fulfilling one or more of the functions set out in the policy. So, so that it comes back to the point about the flexibility inherent within the policy. It explains that when you look at what the policy is seeking to achieve, it sets out its criteria. You don't have to meet them all.
Yeah. And then if you just go to electronic page 4, obviously I've got a number of questions across this re-examination that I need to ask you about these A, B, C. So if we just note them, obviously the first one is the open and undeveloped, which I think you accepted there was some conflict with, that's my case. And then obviously B and C about green networks and public access, which you explained to my learned friend we say are complied with. So the first question related to these, and I'm going to come to some other ones later. In terms of the current site and whether it's open and undeveloped as it stands, have you got Mr. Smith's proof of evidence? I can give you a CD reference if you haven't got one.
So is it
His main proof.
the main proof?
Yeah, it's page 6.
Yes.
So we've got two Google images. Page 5 is the one in 1999, but the one I'm interested in is one on page 6, aerial 2, site's main hub today. You can see what's on the frontage of the site in terms of what's there. Can I ask your view about to what extent do you say now the site as it is of an open and undeveloped character?
It's not entirely open and undeveloped.
And from Luttersworth Road, what's the position?
The developed part of the site is on the Lutterworth Road frontage. When you enter the site, there's the development of the car park, and then there's all the attendant buildings.
Yeah. Now you will ask some questions. I think by reference to Mr. Holliday's answers about possible parallels between Green Wedge and Green Belt. Do you remember
Yes.
that? Can I ask you to go to CD 8.17? This is a Green Wedge methodology agreed by Leicester and Leicestershire back in, I think, 2009,
Yes.
I think, yes. And if you go to electronic page 11, there's a heading, paragraph 3.19, do you see that?
Yes.
And on about 3 lines down, green wedges do not constitute a green belt in the accepted sense, in that they do not seek to restrict the growth of an urban area.
Yes.
Okay. Then talks about what green wedges do, talks about coalescence, etc. What does that tell us about any comparison between green wedge and green belt?
They're not comparable.
No. And if you go to electronic page 17, see there's a heading, Appendix 4, there's reference to the East Midlands Regional Plan as it was. And 3 lines down, although not supported by government policy in the same way as green belts. So what's the difference in terms of government policy between green wedge and green belts?
So there is very clear government policy in the NPPF about green belt, about what is and isn't appropriate development within green belts, and how green belt development should require the likes of very special circumstances and what have you. There's no such designation for green wedges within the NPPF, and it doesn't have green wedges don't have that prohibitive element that green belts have. They don't have the national status.
Okay. Right, I want to ask some questions about Glenparva now, so we will need to go to CD 13.5. And can I just ask you to bear in mind when we go to this, those 3 parts of policy CS16, so A, open and undeveloped, and then B, networks, and C, recreation. So CD 13.5. Is Glenparva, and could we start just on page 8?
Is that electronic 8?
Sorry, yeah, electronic 8, yes, page 68 numbered. That gives the size of the site, doesn't it? 1.9 hectares. Do you see that? The site under the heading, the site, second paragraph. The site extends.
Yes, 1.9 hectares.
1.9, so smaller site than
Yes.
us. I don't think that's. And if you go down to electronic page 9,
Yes.
it says just above supporting documents, approximately 1.1 hectare of the site will be public open space.
Yes.
So as a kind of absolute number, are we providing more or less public open space than Glenparva?
We're providing more.
More. And I put this, I think, to one of the wits, but as a percentage, are we providing more or less?
We're providing more.
More. Okay. Now, can we then go to that paragraphs that my learned friend was specifically asking you about, which is paragraph, I think it was page 22. If you remember, I think my learned friend took you to the paragraph that begins, it begins whilst the development could weaken the defensible boundary provided by Littlegown Road, etc. Development on the site would impact on the functions of the Green Wedge in respect of the merging of settlements. Of those three kind of key purposes that we looked at, A, B and C, which one is this paragraph addressing? In talking about merging and...
Yeah, it's... sorry, this is in respect of the A, B and C. And
yeah, I mean, I know that this was probably actually addressing the list of 4, isn't it, with A,
yes.
B, C and D. And if so, it's addressing A and B in the list of 4. But in the list of 3, which of them do you think that this is addressing and talking about open and...
so it's A.
A, yeah. Now, if you then look at the next paragraph, which you didn't look at, my own friend, which you can see at the end of that paragraph is dealing with B and C.
Yes.
See that? The site is open grazing land, largely lacking in features, presently inaccessible to the public. Is that similar or dissimilar to us, inaccessible to the public?
We're not entirely inaccessible to the public.
But
the golf course is inaccessible.
Yeah. The proposed development will provide an opportunity for increased biodiversity through appropriate landscaping. Similar or dissimilar to us?
We will provide biodiversity.
And an area of public open space which would connect to existing public rights of way. Similar or dissimilar?
Similar.
Yeah. And it says, in these respects, the development would enhance the function of the Green Wedge in this area and accord with B and C listed in the final section of the policy. So if that's the conclusion that they reached there in Glenparva on B and C, is the council's approach in our case, in your view, consistent or inconsistent?
It's inconsistent,
yeah.
Because we do also meet B and C.
Yeah. Now, there was another question put to you about Glenparva that I just want to ask you about. If you remember, my learned friend said to you, when he took you to a plan in your appendices, which you don't need to go back to, showing the development in Glenparva, and one of the points he made to you was the built form that was proposed there, this is obviously about A rather than B and C, didn't go any further south than the existing houses in the settlement.
Yes.
Do you remember that?
Yeah. Could
I ask you to go to Mr. If you've got a yes, it's Mr. Holliday's appendices to his proof of evidence, or actually maybe his. Yes, it's figure 18 is what I'm interested in. Figure 18.
Yes,
So it's almost yes, towards the end of his figures. So figure 18. I just wanted to ask you about this. I mean, we obviously see, don't we, the existing settlement of Blaby, which our development is south of, which is that's obvious. Just how though do we relate in terms of our positioning to the reserve site allocation on the other side of Winchester Road?
We're very similar in terms of the extent of development southwards from Blaby.
Thank you. Now, you were asked some questions about whether, if the inspector took the view that there had been, under CS16, policy failure, by which my learned friend explained he meant the complete merger of Blaby and Whetstone. He asked you some questions about whether that should carry a significant or particular weight for the inspector, and you resisted that suggestion. So I just want to ask you a couple of things to explore that a little bit further. I mean, first of all, I think my learned friend was putting that to you as the council's position. Do we accept that position, that with our development there would be a complete merger and no division between these?
No, we don't.
No. And secondly, ultimately, do you remember we looked at Mr. Baker Adams' assessment of the weight he gave to green wedge impacts.
Yes.
So ultimately, although the council's case is apparently that there is a complete merger and a policy failure, what weight did he give impacts on the green?
He gave it moderate weight.
Moderate weight. Thank you. Now, you were asked some questions about some of the other schemes that are mentioned in your Appendix 10. And I just wanted to pick up a couple of smaller points, really. So first of all, on Abbey Farm, one of the points my learned friend put to you about why it was different, or I think he may have said completely different, was it already had built form on it. Does our site already have any built form on it?
It does.
Yeah, thank you. Now, you were then asked some questions, I think, about the rugby club. I'm not going to go into the detail of that, but do you remember that where you got to with my learned friend on all of these was that you took the view that these showed an inconsistency by the council because they hadn't applied the balance in our case, you said, in the way in which they had in these other cases, i.e. I think the rugby club is a particular example because they found harm. Now, can I just ask you to go to, I'd like to go to Mr. Baker Adams' proof, please. I'd like you to go to his 2.6.
2 points.
6.
Okay.
And you'll see there, he says, without expanding too much on the proof of evidence provided by Mr. Collinge, which I adopt, the development would reduce the open distances between Blaby, Whetstone and Countersthorpe, further merging the settlements, which would be contrary to CS 16A as set out above. What's your view on that as sort of application of the policy test and its consistency with the approach taken in those other decisions?
Well, it's that inconsistency through not then applying. So it's identifying, excuse me, a harm to the green wedge, but then doesn't take the next step within the policy of weighing the need for the development against that harm.
Yeah. Thank you. Now, you remember when we looked at, so you asked some questions then I think about the current access on the site and then also what the position would be with the new footpaths in the site and how they would connect to other existing rights of way. And you remember when we looked at the Glen Parva report a moment ago, the council relied for compliance on B and C with the fact that there would be an area of public open space which would connect to existing public rights of way.
Yes.
Position in our case?
The same.
Same. Okay. Thank you. Now, you were asked some questions on golf, and it was put to you, and you accepted rightly, that the 9-hole golf course, the pitch and putt and the crazy golf, would all fall within the scope of 104, albeit only the first one was sport, the others were recreation. Can you go to the Statement of Common Ground again, please? CD 5.3. And go to paragraph 7.30. It's agreed, therefore, less weight should be factored into any supply or demand considerations in quantitative or qualitative terms of need for pitch and putt, crazy and or miniature golf facilities in the district. So what does that tell us about the position in relation to those facilities when we come to look at them in terms of what's lost and what's provided under 104?
They carry lesser weight.
Carry lesser weight. Thank you. Now, you were asked some questions about the Davidsons' permission.
Yes.
And the timing. How long it would take them to get reserved matters to build out. I want you to help me with this piece. Could we go to the planning permission for Davidson's CD 13.4? Is that right? No, 13.14.
No.
13.14.
Sorry.
13.14. So this is planning permission. Now, I mean, we know from your evidence, the position is that there's a break clause in the contract that can be exercised for the purposes of development.
Yes.
Yeah. And I think the point my own friend was putting to you was, well, there's a lot of steps they've got to go through. I mean, not as many obviously as Enderby, but a lot of steps they've got to go through. They've got to get reserve matters approval, they've got to discharge
Yes.
conditions. So I want to ask you about that. If you go to condition 13 in this planning permission, no demolition development shall take place commence until the necessary programme of archaeological work has been completed. The programme will commence with an initial phase of trial trenching to inform a final archaeological mitigation scheme. Now, we know that the Davidson scheme eats into the actual golf course itself,
Yes.
quite a lot of hole one. Right? If you were advising a client about implementing this planning permission, what would you tell them about what one they needed to do in order that they could carry out the trenching and develop? What do they need to do to get onto that land, in your view? What would you advise them to do?
They'd need to seek the agreement or take control of, seek the agreement of the landowner or take control of the land to be able to do it.
But I mean, if they sought the agreement of the landowner, obviously he doesn't have to give that, and what will it involve if you have to trench a golf course?
Closure of the golf course.
Yeah. Okay, thank you. Right. Obviously, you relied, as you told my own friend, on Mr. Wright's evidence on the quality of the existing golf facilities.
Yes.
You visited the site yourself?
Yes.
So, including the pitch and putt, for example. Have you looked
Yes.
at that? Yeah. So not in a sort of golf professional sense, but in your general sort of planning experience, how would you assess the quality of those facilities in terms of their physical quality?
Not great.
Thank you. Now, you were asked some questions about England Golf and whether we should give significant weight to their objection, and you resisted that suggestion. Are they a statutory consultee?
No, they're not.
No. Who's a statutory consultee on sport?
Sport England.
Do they object to this scheme?
No, they don't.
No. Are Golf England a government advisor or government body?
No.
Thank you. The 11 by 11 football pitch, you were asked some questions about that, and what I wanted to ask you about is it was said, will it be free? Do you remember that?
Yes.
Could we look at the just look at the section 106 to see how all of those matters are to be dealt with? So CD 5.5, I think we can go to. I'm not sure that's necessarily the most up to date, but let's go to CD 5. We've actually got 5.5A, haven't we, in there? 5.5A.
Is it better if I get electronic?
It might
Or
be.
a hard copy, but
It might be.
at least we'll be reading the same thing.
Yeah, electronic's probably better. So CD 5.5A.
Yeah.
Now, I just need to find it on this document. Yep. Sorry, mine's crashed.
I've got a hard copy anyway, so if you've got...
Have you? No, mine's crashed, so I have to read from here. So I want to look at open space. Yes, so if you could go to, this is electronic page 18, you'll see there's a definition of on-site public open space area. Do you see that?
Yes.
Yeah, and you'll see that it says areas of public open space to be agreed as part of the reserve matters approval. And you'll see at the bottom of that definition that the on-site football pitch is included within that definition of on-site public open space
Yes.
area. Yeah.
Yeah.
And then the next provision is, so there's a reserve matters application that has to be made, but in addition, underneath the on-site public open space area scheme means a scheme detailing the location, size, materials, permanent availability, and specifying details for the future management and maintenance, etc., of that space. So
Yes.
how will all this be dealt with?
It would be dealt with through submissions and agreement with the planning authority.
Yeah. And who ultimately has to approve all of this in terms of its management?
The council.
The council. Thank you. Now, you were asked some questions about the golf contribution. Could I ask you to look, have you got Mr. Smith's proof? I'd like you to look at 2 paragraphs in his evidence.
Yeah.
So 6.84, he says the appellants offered 100,000 contribution for the golf provision in the area. Council might be interested in using this contribution as seed funding to build an alternative adventure golf course at the leisure centre. If the adventure course at Blaby were to close, alternatively the funds could be spent improving the practice ground facilities or course drainage at Enderby Golf Course. Ultimately, the council can best decide on where it would wish to allocate the funds for improving alternative golf provision. Okay, so that's what he says there. And then he also says in 8.10, Enderby Golf Course is clearly the more strategically valuable pay-and-play facility, council-owned, longer superior course. And he says the appellant's £100,000 Section 106 contribution to golf could be directed to improving Enderby, for example, towards drainage improvements, enhanced practice facilities, or seed funding for an adventure golf course, generating greater community benefit than preserving Blaby Golf Centre. What interests have the council expressed in discussing any particular purpose for which this money could be used at Enderby?
I'm not aware of them showing any interest.
If the council had said, we want to have a specific provision to spend it on, I don't know, drainage improvements at Enderby or whatever else, would the appellant have been agreeable to that or not?
Yes, I think so.
Yeah, okay, thank you. And ultimately, is your evidence, please, will our development have any, if it goes ahead and Blaby Golf Centre closes, will it have any impact on Enderby?
The impact would be positive in that there would be this contribution, there would also be an uplift in custom.
Yeah. And if there's an uplift in custom, how does that tie in with the contribution?
Then it would, there'd be revenue arising from that.
Right, now, development plan as a whole, you were asked about towards the end. And the point that was put to you was, suppose the inspector accepts that there's a conflict with CS 16 and CS 15. Are you still saying there would be compliance plan as a whole? And you said yes, and you had an exchange with my learned friend. I mean, just about the likelihood of that scenario. I mean, okay, let's say the inspector accepts a breach of CS 16, park that one. Policy CS 15, we've agreed with the council, it's inconsistent with the NPPF. It's been superseded by the NPPF.
Yes.
And it carries very limited weight.
Yes.
So how would that affect, if, in your view of at all, the overall compliance with the development plan, even if the inspector found a conflict with CS?
That it's not relevant to the compliance with the development plan. It's a not relevant policy.
Yeah, and coming back to a point I raised with you earlier, but this time by reference to CS 16, if the inspector finds a breach of CS 16, so impact on Greenwich, on the council's own case, what weight do you give to that conflict to Greenwich? What does Mr. Baker Adams give that?
Mr. Baker Adams gives it moderate weight. I've said limited weight.
Yeah. You then, I think, took my friend to CS1 and CS5 because they are policies that are agreed to be most important to the scheme. And he said, well, they're also out of date. Yes.
Yes.
Do those policies, what's the nature of those policies? What do they do?
So unlike the other two, 15 and 16, they're not restricting development. They're directing development.
And does that have an effect on the weight you give to them, even though
Yes.
they're out of date?
Yes.
Yes. And then finally, could we go back to the on this policy point? And I think I've got one other small thing, but on this policy point, could we go back to the statement of common ground, please?
Yeah.
And I'd like you, please, to go to the tables which set out the various relevant policies. If you could just go to those for me.
That's section 6.
Yeah. Yeah, that's right, section 6. Now, if you then go to those tables, I just want to look at some of those policies with you in CD 5.3, because obviously these are policies that we agree to be complied with. They're the policies that pull in favour of the scheme. So they're not, though, are they, a number of these, apart from the ones that are asterisks, they're not policies that are agreed to be the most important for the purposes of paragraph 11.
That's right.
Right. So they're not deemed to be out of date, I think was the point that you made to my learned friend. Is that
Yes.
right? So just in terms of ones that we comply with, then, table 1, I'm not going to go through all of them, but we comply with CS7 and CS8, which is about providing affordable housing and the mix of housing.
Yes.
How important are those policies?
I think they're very important policies.
Up to date?
Yes.
Yeah. CS19, biodiversity, including net gain.
Yes.
How important?
That's very important policy.
Yeah. In date or out of date?
That's in date.
CS24, presumption in favour of sustainable development.
Yeah, that accords with the development, with the MPPF. It's
Yeah.
a
Important.
important policy, yes.
And then on table 2, again, I won't go through them all, but providing accessible and adaptable homes. How important is that?
That is important policy.
Yeah. Up to date or not?
Up to date, yes.
Yeah. And then the neighbourhood plan, which we know there's no alleged breach of, but BMP1, character and environment, BMP8, design of new development, complied with. How important are those policies?
They are important policies.
And are they up to date?
Yes.
They are. Right, one final thing then, please. You were asked some questions about the replacement retail sui generis units on the site. And I think the point was put to you that they were net neutral in terms of any kind of benefit. And obviously you attach, I think in your proof, a moderate benefit to that. Now, can I ask you to go to your appendices, please, to the Appendix 1, where we have the assessment that's been carried out by Mr. Cook in relation to the economic benefits. Now, I put quite a lot of this to Mr. Baker-Adams. What was your understanding? Were these matters in dispute, the content of this report?
No.
No. Can I ask you to go to page 11 of the document? So, at paragraph 5.6, Mr. Cook challenges the idea that there could be 47 jobs on site.
Yes.
And he says, realistically, 24 jobs currently on site. And then at 5.10, he says, based on the methodology outlined above, it's estimated the floor spaces of our replacement could support up to 31 full-time equivalent jobs on site.
Yes.
So 31 versus 24, is that net neutral?
No, as he says there at 5.10, this is higher than the job estimate outlined, paragraph 5.6.
Thank you very much. Those are all my questions.
Thank you. Nothing from me to discuss, and so you
Thank
can
you.
step down. Thank you. Right, so I think we're at the end of the witnesses then, so that just leaves 106 and conditions. Can I suggest we do have a lunch break? I think probably those would take probably 3/4 of an hour, 50 minutes, maybe an hour. But do you want a whole hour for lunch, or do you just want? Okay. Shall I say 40 minutes then? Is that long enough? Is that long enough for a comfort break, a sandwich? Okay. All right. Well, let's resume then at 13:35 then. So the inquiry is adjourned till 13:35. Thank you. Okay, so the inquiry is resumed. So can I suggest we discuss the legal agreement and then the conditions in that order?
Yes, sir.
Yeah, okay. Can I firstly thank the council for the SIL compliance statement? I've literally only managed to just quickly skim it, so forgive me if I sound a bit vague in relation to it, so apologies for that. If there's anything that does occur to me beyond today, I'll raise it prior to closings or either in writing via the case officer. So, but I doubt that will be the case, but I'll just, dare I use the phrase, reserve my position in that regard. So I'm quite happy for a sort of more of a round table informal format. I'm not quite sure how that will work with the microphones, but we'll see. Yeah. Probably start by asking each party if there's anything you particularly want to draw to my attention. I'm grateful for the briefing note. I don't always get them. They are very helpful for future reference, so I'm grateful for that. But perhaps I'll start, Mr. Morisi.
Yes, so there's only one thing that I specifically wanted to draw your attention to, which is if you look at the legal agreement, electronic page 29, so I think I'm in CD 5.5A, which is, but it's electronic page 29, it's numbered page 29, clause 2.7. So that's the standard sort of blue pencil clause, and obviously, I mean, there's only one contribution that's in dispute, which, as you know, is the golf provision contribution, which the council say doesn't meet the SIL test. So we would need a finding in your decision, one way or the other, about whether that meets the SIL tests, because obviously if it doesn't, then your decision in so finding will make that obligation fall away. I mean, so I think obviously in theory, of course, it's open to you to find any of the other obligations are also not SIL compliant. And I know obviously you've only just seen the council's SIL compliant schedule. But again, if that's the case, then obviously you have to make that finding explicit on the face of the decision letter. So that's the only thing I would particularly draw attention to. And I think it's the only point that, as far as I'm aware, it's the only point that's really in contention.
Yes, sir, that's the only point in contention. That was the only thing I was going to draw to your attention, the blue pencil clause.
I'll use the microphone. I'm assuming both parties feel that issues had adequate coverage, or is there anything that you would like to draw to my attention?
Not on my part, so I think we've had that out in the evidence for various witnesses, so we can make submissions on it. I mean, I'm sure we will both cover it to some degree in our closing, so no.
Okay. Similarly, Mr. Robson, is there anything the council would like to draw to my attention?
No, thank you, sir.
Okay. There's just a few bits, probably more wording on that. I'd just like to go through. But before I do that, it might just be my reading, but I just wasn't sure where the stance was on just flicking through the still compliance statement on the police aspect, because I think I'm right in saying that that at 4.4 there's a suggestion that it doesn't comply, and I think that's what Ms. Morici alluded to earlier, if that's right. But I wasn't quite sure how that went on later on in the document, or whether there's a drafting error, or if I've read it wrong. So perhaps, I don't know, Mr. Baker-Adams like to just sort of explain the position in terms of the police one.
Yes, I think there are two elements to the police contributions that we do believe are SIL compliant. It came through a decision on Oak Road in Littlethorpe. There were, I think it was, let me just check. Yes, but police vehicles and identification technology, they were the two that would seek, well, would feel are still compliant.
Right, okay, so I think that's one of the schedules. So is it under the county council or is it a separate one?
Police force contribution is defined at page 20 of the obligation, and obviously that what we've provided for relates to those two items that Mr. Baker has just referred to. So we've not included the additional requests from the police because, well, they're not really considered to be compliant by the council or indeed by us. I mean, effectively, I think they were asking us to basically fund officers, which, as I said to my learned friend, I don't know what will be next in Section 106. They'll be funding the army next, I think. But
sorry, I should use microphone. Terrible. If I'm going to refer to it, it should be an inquiry document.
I'll check for you, just give me a second.
Well, but no, I'm not aiming to put you on the spot, but what I was seeking is if it's not there, I presume the appellants wouldn't have any objection to it being submitted.
no, so if the council says it's in, we'll add it to
Yeah, so don't worry at the moment, Mr. Baker Adams.
I think so, it's in CD 5.2.6.
CD 5.2.6, okay.
There's the appeal decision. It's paragraph 41. In terms of the police, the obligation provides for a sum of 7 million up to 5,800 to police vehicles, just short 2 to identification technology, each of which allows for development to be. I understand from Mr. Baker Adams that the police have sought those previously, and the council said no previously, and the council said no to them at Littlethorpe, and so we ended up in exactly the same situation as we are here, being the 2 for vehicles and identification technology.
So, Mr. Baker Adams, can you just confirm then that that's standard council practice? Because you obviously get quite a lot of major applications, so in terms of consistency, in terms of the approach to contributions to the police?
I can say this process is under review. We are, I don't know, state of discussion, shall we say, about the level of contributions that we request from the police. But from the council's point of view, I think for the foreseeable future anyway, we'll be looking to only accept these 2 as as still compliant.
Okay. In that case, then I'll move on. I've just got a couple of aspects on wording that I don't need anything conclusive, but just today, but just perhaps thoughts to take away. If it's all right, I'll just go through the document. Most of which relate to the definitions. On page 6, it's referred to, the site's referred to as application land, and we've got an appeal here. So there's a few references to the word application throughout the document, and I just wonder if, strictly speaking, the definition, it's probably easier to keep the title as application land, but is there a need for an extra line to say that actually it's the one red line that's been determined in the appeal rather than the application?
Yes, I mean, we could change it. I mean, I've just done a search. It's got 40 references to application land. I mean, I think really the only requirement is that it properly identifies the land, which it does by reference to the land registry document. And obviously the application land hasn't changed into the appeal. So although if we were being, I think, fully neat, it probably would say appeal land, I think it's probably okay to stay as it is. That would be my view.
So you're happy with that, Mr. Robson? Okay. Right, okay. I wondered if, sorry, on page 13, sorry, I'm using paper, I should say, rather than PDFs. Oh, well, that's unusual. Yes, a rare treat. On the definitions of the golf contribution, I just wonder. Again, I'm not expecting an answer today, but just wonder if it's worth reflecting whether or not that definition is overly restricted and/or could include, for example, an indoor facility, or whether that's catered for in terms of interpretation. I just wondered if that reflects the discussions of the last 2 weeks.
There is no definition of golf facilities within the agreement, I don't think. So, I mean, I would have said that would be, I mean, if it was found to be still compliant and the money went to the council, it could be applied to anything that was golf related, because it's so broadly defined. So, I mean, again, so if you want to, I mean, we could change that to say golf facilities indoor and outdoor. There would be no, I mean, that wouldn't be a massive change. But if that's something that would be useful, we could certainly do that.
Mr. Robson.
So we'll take that away. I can't guarantee you we will change it, but we will take that away and think about whether we should.
Yeah. Page 17, we've got reference to an on-site football pitch, and I wondered if the agreement shouldn't be specifying the size, because a toddler's football pitch is a very different size to, I think it's been described as a youth one.
Well, I think it's described as 11 by 11, isn't it, in various things? So we probably should include that, because that's the way we've presented our evidence. So yes, we'll need to say means a football pitch, 11 or 11 by 11 football pitch, 11 v 11 football pitch.
Yeah. I think it ties in, because when we get to conditions, it's shown and annotated as an 11 v 11 football pitch in the illustrative master plan. Check, and I think the landscape plan is conditions.
Okay, are we happy with that? Yeah. Yeah, that's fine. We will make that change. Yes.
Probably me being very picky, but sports facilities on page 24, there's reference to a word I didn't understand. Under C, there's reference to Northfield Park in support of overplay and overall cricket provision. I just wondered if the word overplay has had the perhaps autocorrect, because if it's the wicket, a wicket wouldn't be the outfield. So perhaps that is just, again, a question of clarification.
I think it comes from, so if you look at CD 3.12, the BDC Health and Leisure Response, they talk about, this is at the top of electronic page, the closest cricket club to the proposed site is Northfield Park. When looking at the PS document, the site is currently overplayed by 2 match equivalent sessions a week. So I think it's trying to refer to that, but I don't really know quite how that works in terms of the definition. But so let's just go back to the definition. Support with overplay. I mean, I guess it's trying to say support with the issue of there being too much play on the cricket pitch.
Yes, I agree. That's the genesis of the term. I don't think it's helpful at all in section 106. I think the council wouldn't want to have the contribution to Northfield Park limited only to the square. I think they'd also want to be able to, for example, reseed parts of the outfield if they've become overused or need further work.
So again, shall I leave that with you, with both parties?
Yeah, I mean, it could just say improvement to the overall cricket provision in Blaby East, if everyone's happy with that. Yeah.
On page 26, again, is the waste contribution, and I think this has probably come from the county council, but 2/3 of the way down it says which shall be used towards site reconfiguration and or development of waste, and I wasn't quite sure if site reconfiguration was the right word. I mean, it's a funny term.
We just wanted to say to increase the capacity for the wet.
Just going to look at their response.
I'm not sure what. I think it might be overly restrictive to have that in.
Yes.
I wonder if it's just index linked payable by the owner to the county council to increase the capacity for the Whetstone HWRC or any other HWRC directly impacted by the development. Which means if it's about shifting things around on an existing waste recycling centre, you can use it for that. If it's about extending a existing centre, you can do that.
Yeah, we're happy with that. So it would just be to be used to increase the capacity of the HWRC or any other HWRC directly impacted. To increase the capacity at Whetstone Household Waste Recycling Centre, HWRC or any other HWRC impacted by the development.
Similarly, again, just a bit of wording that perhaps just needs a bit of clarification. On the same page above, we've got TRO contribution, and I understand why the contribution is so proposed, but the wording talks about consultation, and that's part of the TRO process, but with the word consultation in the middle of it, it almost implies that there'd be a consultation with a view of whether or not to proceed with a TRO rather than the possible contribution within that process. So I wondered if that was actually necessary or helpful wording. Just as would it be simpler to say a contribution to the TRO process rather than inferring a consultation which might almost imply it's before the TRO is started?
I think so. If you just removed the word consultation, then it would be towards the submission of a TRO, which means it could be used at any point in that process.
Yeah. Okay. I think lastly, on page 43, I wasn't sure, and it just might be me, I will accept that there wasn't actually a commencement trigger specified to require the on-site football pitch. Again, I'm happy to leave that with both parties, but there's references in the dialogue below to the on-site public open space, but I couldn't, given that the two are separated in the heading, I was then looking for some other wording to deliver the on-site football pitch, because they're under the same heading, and I didn't see that they were connected in the definitions.
I think they are connected in the definitions to some degree. So if you go back to public open space, if you go back to page 18, the definition of on-site public open space area does include at the end the on-site football pitch.
I'm still looking for...
So page 18, there's a definition of on-site public open space area, and then it means the area of public open space to be agreed as part of reserved matters application, and then it talks about what it consists of. It says to consist of informal open space, natural green space, the on-site football pitch, the on-site play area, and a sustainable drainage system. So if we then go back to 43, so it's the open space area scheme will have to include the football pitch, because that's part of the definition of the open space area.
Okay.
And then I think all the other provisions, including commencement, will be triggered by that.
Are you happy with that, Mr. Robson? Mr. Baker Adams? Or?
Yeah, I mean, I was going to say, should it maybe say all open space, and then that's everything? Does that help?
Well, I think the problem is the public open space has that definition, which includes football, so it's already in. If we put another definition in, we'll have to redefine it.
4.1.2 creates a legal obligation to provide everything that's in the defined on-site public open space area, which includes the football pitch, prior to the occupation of the 85% of the properties, of the dwellings. So by 85%, everything in that open space, on-site public open space area definition needs to have been provided. And if, for example, they didn't provide the football pitch, well, then they'd be in breach of the 106, I think.
Okay, thank you for that. Well, that's all my questions on the legal agreement. Is there anything either party wants to add to?
No, so you've kind of given us, I think, 3 weeks.
Yes.
Is that 3 weeks from today or 3 weeks from the close of the inquiry next Thursday?
So that's a good lawyer's response. I'll say 3 weeks. I do normally say 3 weeks from the closing inquiry, and we have got bank holiday. I appreciate some people are probably likely to take half term off as well, if they have such responsibilities. So yeah, I'll say 3 weeks from Thursday, whatever the date that is. Sorry, I've not got my...
No, that's great. Well, that's very helpful, sir. And obviously, the only changes we will make are the ones that we've specifically discussed today that will be changed, and then we'll get it signed by everybody.
Okay. Okay, so let's move on to conditions. Ms. Marici, is there anything that you'd like to draw my attention to? And I'll ask the same for Mr. Robson.
I don't think so at this point, sir, because there is, I think, largely agreement on those conditions now, in the light of your earlier note. So really, so it's just if there's any queries you've got on them as they now stand.
Okay, Mr. Robson, I'll just give, before I dive in, I'll just give you the opportunity.
No, sir, that position's correct.
Okay. Okay. So just going through briefly, so that the first condition, both parties take the view that meets the sort of tests as well as the housing land supply situation. Yeah.
Yes, sir. I mean, it's obviously shorter than the 3, so it can't be shorter for various reasons, including we have to give 6 months' notice to the golf tenant. Do
you want to elaborate on that?
Yeah. So there's, under the lease, there's a 6-month notice clause to get the tenant out, and clearly, as I think I was talking about in relation to even the Davidson scheme, we're going to have conditions that require trenching on our part of the site too. So the golf course would have to go, which means we have to give notice. There'd be a 6-month period, and then we could start all the things we needed to do on the site. So that means 2 years is fine. We can do it, but anything shorter would be difficult given that.
I think I'm right, Mr. Baker Adams, that's the same condition that's put on Glen Parva. But don't worry. Don't worry. Okay.
It's the same on the Davidson's permission for sure.
Oh, sorry.
So it might be that one. It might be that
my
one.
apologies.
Yeah.
That's the one I meant. Yeah. Okay. I knew I'd seen it somewhere this morning. Okay. Thank you. Moving on then, in terms of compliance, we've got their condition 4 in terms of connection with the open space. I mean, that's not quite the same as the master plan. If I'm right. Oh, that's the core documents. Let me get that up.
So I think what this should be is, if you've got Mr. Holliday's proof.
Yeah. His proof or his appendix?
No, his actual proof.
Oh, is this the one on page 30?
Page 30, that's right, sir. Yeah. So
again, I'm looking at on paper rather than
that's what
electronic.
I was going to say, that's what we intended it to refer to. Because remember, that's the proposed condition that we put forward.
Right. Okay.
Actually, I'm not sure. Is that right? Yeah. Okay. Can we just check that and we'll come back to it? We just need to check that because
thank you. It's quite often I spot this, so it's a favourite chestnut. I was just going to give both parties an opportunity to comment on condition 29, because I understand that's still in dispute, so I don't know if either party wants to comment on that or not. I see Mr. Baker Adams is poised.
I think the arguments from the council's point of view is this is a very specific condition. It provides very specific information that I think needs to be adhered to, and it's also one that's obviously come from the highways experts. So I think that they're the main points really, our perspective on this one.
Ms. Marici, Mr. Cusson, any sort of thoughts I should take away on condition 29? The highways access point.
There is a proposed approved access drawing, which is in condition 3, which details the immediate access and the visibility displays and the like on Lutterworth Road. So that ties what the access is, and that would accord with those guidances within there. And then I think it was really just that then it was felt it was preempting what might be in the reserve matters in terms of being very specific in terms of the council's wordings. What we've taken out is some of that specificity to allow the flexibility within the reserve matters to still fall within the Leicestershire Highway Design Guide, but it might be that not all of that specificity is required once we get to the point of reserve matters. But it would still be something that was compliant with the design guide.
So, does the approved plan on condition 3, does that comply with the county's design guide?
It does, yes, for the area of the site that it covers, because it only goes 20 metres or so into the site, which is the immediate access, and the visibility display and whatever would be the 278 works out with the site as well. So all of that is compliant and meets those standards.
So is a suggestion of 29 then that's carrying on into the site and it's looking to control the access into the site? Is that, have I got that understanding right?
It's how the access road within the site would be designed. Yeah.
Mr. Baker Adams, anything more from your point of view?
Not particularly. Again, it's one of these conditions that we've just lifted off from the council's, the county council's consultation response. Again, providing that specific data. Yeah, obviously they take all their guidance again from the Leicestershire guidance themselves. So, yeah, it's one of those things. I think we're both right.
So, Mr. Casson, your view is that there may be some possible opportunities without specifying the width. Yeah. Would you like to elaborate a bit more on that, or? Yeah, please.
Sorry. No, that's fine. So I think from our point of view, the access into the site, and as Nigel said, 20 metres within it is controlled by the drawing, which is referenced previously, and then the road widths and the footpaths within the site will then be controlled and approved by the local authority as part of the reserve matters. So in our point of view, the conditions sort of covered by those two and doubling up in effect.
So what you're saying is the reserve matters would have to look at the adequacy of the road layout in that context. Yeah. Mr Baker Adams, I'll give, well, I should give the appellants the final word on this, but that's the normal convention, but anything to add?
You've got a condition that requires, they're seeking detailed planning permission for an access. You've got a detailed access that's proposed and conditioned that's satisfied the local highways authority. And that's just what's required to come forward. You've then got a condition that relates to the proposed access. I think you've got my point.
I've got your point, yeah. Okay. Condition 35, lastly, has been reworded as well. So I think with the exception of the open space master plan.
Yes, so
yeah.
on that one, so that is the wrong plan that's referred to. Right. So the relevant plan is the one that is it's Appendix 3 to Mr. Holliday's proof, which is the penultimate page of his proof and appendices. Yes, sir. So CD 14.5, and it's electronic page 29. It's CD 14.5, electronic page 29. So this is the kind of full plan version of what you saw at page 30 of the proof a moment ago. So, sorry. 14.5 is electronic 29. No. Yeah. So it should refer to this plan, but so what it should say is, at the moment you see the condition says, for the avoidance of doubt, no built development shall be permitted on the area identified as strategic open space on the plan. I think it should say as green infrastructure only on the plan, because that's what's shown on the plan. So we need to change two things. We need to change the plan reference to this one, and we need to change strategic open space to, should say green infrastructure only.
I'm looking at FPCR plan page 30, CD 14.5, plan 0012, A01, annotated green infrastructure only, residential development.
Yeah. That what it's called? Yeah, that's what it's called. Oh, so it's in the condition, sorry, in the condition, because condition 4 should refer to that plan, not to the open space. And then if you look at the condition, it refers to areas identified as strategic open space on this plan, but the plan doesn't identify any areas of strategic open space. So I think it needs to say green infrastructure only spaces, because that's what's being identified in the plan as where you can't build. Are you happy to take away those changes, or do you need us to put that in writing?
I'll just give Mr. Robson a chance to...
Yes, sir. So the plan originally referenced the open space provision plan, which CD we went to earlier. 5.1.7. I think the council's position is that added detail that's shown on that plan means that it's... Oh, I'm sorry, yeah, CD 5.1.7. 1.7. So that's the originally conditioned plan. We're now going to CD 14.5, page 29, which is the big block plan rather than the detailed blob plan, for want of a better word. The council's concern is that if you move from the open space provision plan to the green infrastructure and urban form plan, there's nowhere captured, I don't think anywhere else, the 10.5 hectares of open space and green infrastructure, which you've heard a huge amount about from the appellant as a key part of their case, and I don't see where else it's captured. So the risk is that the condition 2 could then, the developer has to have some freedom in how this is going to come forward at reserve matter stage, obviously, but the council needs to be able to hold its feet to the fire for the 10.5 hectares that it's relied upon as one of the key benefits it's proposing.
I'm going to add to your comment in a minute, and I'll just reach in for comment, but this plan on CD 5.17 would capture that. Is that what you're saying?
It seems to capture it better because it's an overlay on, broadly speaking, on the illustrative master plan.
Can I leave the witness as well, saying that it also covers the frontage to Lutterworth Road
Yes.
as well. So Mr. Parigi, what's the appellant's position in terms of the relative benefits of the plan? Existing instructions for them. Yeah. I mean, if you want that plan, parties.
If it's going to give the council the satisfaction it needs on this, then we're happy to go with the plan that's originally in the condition. I mean, it does restrict us a bit more on what we can do. Although I think it does say, doesn't it, shall generally adhere in the condition.
Yes.
So there is a little bit of room for manoeuvre rather than strictly adhere. But I mean, I accept it does capture that area at the front that of Lutterworth Road, which we have talked about and relied on. It does better capture the sort of 10.5 hectares that we've relied on. So, and of course it does, I mean, it's pretty similar, I think, in terms of the division between built development and non-built development. So, we're happy to stick with the original one.
Yes, I think so, sir. And just to so that it's clear, I don't think the council's seeking to be unreasonable. You need flexibility. If permission's granted, the council obviously wants the houses to be built for obvious reasons. So you need the flexibility, but we want the 10.5 hectares because it's a big part of the scheme.
So in terms of the conditions, anything else either party would like to bring to the attention?
No, sir, sorry.
Well, I think that brings us to the end of the conditions session. Just a few bits of housekeeping from me. Firstly, I just need to clarify whether either party wishes to submit a costs application. Okay, right. So that will only leave us with closings on Thursday. I will look at the site next week. I did say, if you can remember way back to last week, that I'd confirm if there was anything else that I should look at on site. Miss Marici did ask me to go to Enderley, and I will do that. Just to confirm, is there anything else that you'd like me to look at apart from the route that
No, sir.
being provided?
No, sir.
Okay, all right, that's helpful. So I think that just leaves arrangements for next Thursday, We'll start at 10 o'clock. I've got the link, so thank you for that. Mr. Robson's heard previously from me about my nervousness of such proceedings. And last year, by a nameless council, I was in the lobby till about 2 minutes before, which was not very helpful to my stress level. So I will aim to be in about 20 minutes before and then mute and then unmute just prior to opening. So if I can ask the council to be on standby. So the logistics would be that the closings will have to be emailed to the case officer. I will make sure that somebody at PINS is covering that eventuality, but it has to go from the case officer or somebody else's inbox to mine, and there's obviously a delay for the pigeon to do that. So please can you bear that in mind. So what I would probably look for is a comfort break between both closings to help that logistics. But if you can just bear that in mind, that there is that delay, because I certainly prefer the reading of the statements when I've got a copy in front of me. I have got 2 screens at home, so one screen for Teams, the other for reading such documents. So that's how it'll work. Okay, right, okay, great. Well, I think that's all from me. I'll just check both parties. Any more? You sure? Okay, well, in that case, can I thank the council for hosting the last 2 weeks and their hospitality and efficient arrangements. So thank you for that, and for the members of the public that have participated. So I'll do a formal closings myself electronically on Thursday. We've set the date for the 106 as well, and I will also look at the site again next week. So can I thank you all for your participation and wish you a safe onward journeys. So many thanks. So inquiries closed for the day. Thank you.